Good morning. It is the 25th of September, 9 a.m. This is the Energy and Carbon Management Commission. We will take a roll call.
Commissioner Ackerman,
Here.
Commissioner Cross,
Present.
Commissioner Mesner,
Here.
Commissioner Oath,
Here.
Commissioner Robbins,
Here.
and Commissioner Shea.
Here.
Mr. Chair, you have 6 commissioners present.
6 is a good number. It is a quorum. We exist for purposes of doing our business today. We are continuing with the Cumulative Impacts and Enhanced Systems and Practices Rulemaking docket 240600145. Notice how calmly that rolls off my tongue because we've been doing this for a few weeks. Today, we have a few substantive issues yet remaining. We are going to take up the topic of air emissions and no net adverse impact, which is a foundational topic assigned to Commissioner Oath. We are going to take up the notice matrix that our staff has put together so that we can sort of get our heads around that. I'm going to have a discussion around cumulatively impacted communities and setbacks. And then we are going to roll through AAG Davenport's list of foundational issues to try to get a sense of where we are on consensus and non-consensus on foundational issues. I then anticipate that we would walk through the August draft. So start at the beginning and just sort of walk through and see if we have consensus on whether we have agreement on areas, and then talk through areas in which we don't have consensus. I anticipate this is going to take today and some of tomorrow. At that point, we will continue this hearing to do a few things. One, allow staff some time to be able to draft and get back to us with hopefully a consensus version of what it is we're coming to. We have some commissioners that have conflicts starting Friday and next week, and therefore we are going to reconvene on October 8th, assuming we don't get this thing finished between now and tomorrow afternoon. And then we would also set aside October 15th for final deliberations. So just giving everybody a heads up, we are not able to meet next week, nor are we able to meet this Friday. The 8th and the 15th would be the next 2 days of. I and my fellow commissioners are well aware of this statutory deadline that we're supposed to get this done by September 30th. I'm just giving everybody a heads up that getting it done versus getting it done correctly, I believe that the second piece of that is the most important, and sometimes it takes a little more time to make sure we're at the right spot. So I would hope that all of our stakeholders understand that the commissioners have been diligent in their work on this important topic, these important topics. And we've had a lot of stakeholdering and a lot of back and forth and a lot of discussions. And I think you can hear from the deliberations of the commissioners that we take this very, very seriously. And we're trying to achieve the best outcome for the state of Colorado that we can. That might mean another week or so, but we're going to get it done. And we're going to get it done in the correct manner for our state. So bear with us. We've got some more work to do this morning. That's our daylight into what the next week or two looks like. Looking around to any commissioner, does anyone have any thoughts, questions, concerns about process as laid out? Commissioner Messner?
Just a confirmation. I mean, at the beginning of deliberations, we talked about the assignment of foundational issues and going through those, but I also want to make sure that there's room for individual commissioners to be able to identify issues that were not on the foundational issue list that perhaps should be deliberated on as well. And so I just want to highlight that as a piece that may need to be discussed as well. Now that can be discussed as we walk through page by page of the draft, or we could save some time for that as well.
What's your preference there, Commissioner Messner? Do you want to have a chance to talk about issues that you find that were not on foundational issues list ahead of draft walkthrough, or do you feel that you could be accommodated as we walk through the draft? I'm agnostic. I'm happy to hear you out and allow you to help us understand how you want to approach that.
Yeah, and while I have one that I would like to walk through before the draft, I don't want to think that I'm the only one that may have things on their list that weren't fully captured in the foundational items. And so there may be other commissioners that have items, but I do have one that may be better served by discussing it prior to the walkthrough of the draft, because it is a procedural piece.
Okay, let's set aside some time before the page by page walkthrough to allow you and other commissioners, any of us, an opportunity to identify other issues that didn't make the foundational issue list, but that are important. Commissioner Oath?
That sounds good. I was just going to chime in and say I had a couple also, so that plan sounds good to me.
Okay. Commissioner Ackerman?
Thank you. And I wonder if that might be a good time to give any specific basis and purpose type thoughts, or are you thinking maybe later on during the draft walkthrough?
I'm wondering if the statement of basis and purpose thoughts might be accommodated as we do the walkthrough page by page, because then we can add pieces to a specific rule in the SBP to help flesh out what commissioners are thinking, so that we've got a rule and an SBP that survives the existence of the 6 commissioners that are in the room today.
Sounds great. Thank you.
Other thoughts on process, procedure, or anything else before we get rolling? Commissioner Oath, you are recognized.
Okay.
Oh, actually, hold on. Hearings manager showed up. We always got to take care of them.
Apologies, Commissioner Oath. Chair Robbins, we do have a consent agenda this morning,
Oh,
so just a reminder.
thanks. We have a consent agenda. Does anyone have questions on consent? I would move approval of consent. Do we have a second?
Second.
Any questions, thoughts, deliberations on the motion before us? All those in favor of the motion signify by saying aye. Aye. Any opposed? Consent carries. Hearings Manager Thomas, anything else I missed on, because I didn't go back and look at the agenda?
No, that is it. Thank you.
All right, thanks so much. All right, Commissioner Oath, please.
All right. So these 2 topics are quite meaty and topics. And they are 2 very separate proposals, but I kind of want to talk about them together. And the reason for that is because in my mind, I think that they are both trying to get a bit at the same concept of how do we and what is the right way for us in these rules to make sure we have a way to evaluate and determine whether or not the bathtub is full. With all due apologies to our folks at CDPH, you do not like that analogy. It is, it is a concept that I think has come up in a number of contexts and in these 2 proposals as well. So in my mind, I just kind of want to talk about them together. So the first one is about air thresholds and has a lot of parallels to the comments that Commissioner Ackerman made previously in our deliberations about wildlife thresholds in many respects, but somewhat different as well. There were, a number of components to this. One aspect of it would be a proposal that would require some baseline air monitoring. And we heard a lot of comments around duplication of efforts with the Air Commission's Reg 7 requirements and where I come out on that is was less focused on that. I think the proposal itself took that into account to avoid kind of duplicative efforts, but building on that, the concept would have ECMC then establishing basically air thresholds, and then using data to evaluate whether or not those thresholds would be exceeded with a proposal. And that's where I come up in my thinking of what is the role for and what is the right things that ECMC should be doing versus the Air Commission in this context. So the first piece of that, the establishing of thresholds, I see as pretty similar to establishing of standards, right? What is kind of a level that is too high of a risk that it should not be tolerated. And that's a really incredibly technical and complex undertaking. In my mind, I've seen and been involved in many of these types of exercises, and it's really technical, right? You're basing it on specific criteria and often involves, toxicologists and whatnot, kind of evaluating what are the different factors and what is there for the appropriate threshold or the appropriate standard. And I felt very much the way Commissioner Ackerman said, I think used the phrase, like, I don't feel that we are anywhere near ready to do that kind of a thing. And I also don't feel like ECMC is the right agency to be doing that kind of an assessment in terms of establishing the standards or the thresholds. And then the next part of it, if we were or did have some thresholds or standards, would call on us to be doing what in my mind would be a pretty complex modeling analysis to evaluate whether or not, with what's in the baseline and with what an operator would be proposing to add in terms of air pollutants, whether or not when you mix that together in a modeling exercise, that would exceed a threshold or a standard that we had set. I don't think that we have that type of expertise. I think that is the kind of, that is precisely the exercise that is done in an air permit. Don't want to get into the complex details, but there are a number of steps that the Air Division goes through in evaluating a permit application, and it is, in my mind, precisely that. It is looking at background conditions. It is looking, which means looking cumulatively at what are the monitors saying in that area. So picking up kind of what's happening cumulatively in an area, and then adding in the potential to emit, so the highest volume that an operator might have the potential to add, and doing a modeling exercise to evaluate whether or not the standards, which are based on health-based risk assessment, whether or not those standards would be violated. And if so, then either the permit is not issued or additional control measures are required in order to ensure that operator will not contribute to an exceedance of the health-based standard. So that's my thinking on the air thresholds issue. The no net adverse impact, like I said, very different proposal, but trying, I think in my mind, still trying to get at this concept. I want to acknowledge that, we've talked on the record about some legal advice that we have heard from our AAG Davenport about litigation risk with this concept. I appreciate Green Latino's response to that and different perspective on this. One thing that Green Latino said is we have to be able to say, like, this is the straw that breaks it and no more impacts can be allowed. And I agree with that in many respects. Although I would phrase it a little bit differently, right? I think we need to be able to say, like, there are existing impacts in the area, and either those impacts are already too great that no additional load can be carried, or that a particular proposal is going to be adding too much to that overall, such that it should not be approved or move forward. And so I think to me, it's what is the way to do that? To me, in the August draft, section 315B3 is the part that requires the commission in our review to review that cumulative impact analysis, which is going to have a lot of information in it, right? It's going to have a lot of quantitative information in it, including quantitative air emission information in it, as well as a lot of qualitative information in it. And then it says that, and then the commission needs to make a determination about whether or not that cumulative impact analysis adequately evaluates and addresses cumulative impacts. And then lists out a number of factors. And in my mind, I think the right factors and a really robust set of factors, right? It is the efforts to avoid or minimize adverse cumulative impacts, the actions to mitigate those that couldn't be avoided or minimized, adverse cumulative impacts that would result from the application, the beneficial cumulative impacts that would result, and then engagement with nearby residents, the public comments that were provided, alternative locations, the relevant local government land use permits, the results of our consultations with various agencies, and then also that operator's record of compliance, historically with our rules and our act. So in my mind, I think this standard of having to evaluate whether or not it adequately evaluates and addresses cumulative impacts does exactly this. It gives us that ability to evaluate whether or not on whole, whether or not a proposal is or is not going to contribute too much that the bathtub is going to overflow. What I don't think it does, and so I think where we can improve here, is explicitly state, so if we do make a determination that we feel like the proposal does not adequately address the cumulative impacts, we don't really say what the result of that is, and maybe it's implied that we could deny the application, but to me, I think that's precisely what the result should be. If we make that evaluation, then I think that we should be explicit that in a case where we feel like those cumulative impacts have not been adequately addressed based on the factors that were specified, then either we can deny an application or impose additional COAs to ensure that the cumulative impacts are adequately addressed. So overall, that is my thinking kind of on the way that we ensure that we are taking this information and really evaluating it and making sure that the proposals adequately address cumulative impacts and avoid the bathtub overflowing.
So Commissioner Oath, what changes, et cetera, do you advocate to August draft?
I should have probably drafted it. I see it probably as a sentence or so in 315B3, stating explicitly that, if the commission finds that the cumulative impact analysis does not adequately evaluate or address cumulative impacts, then the commission can add additional COAs or deny the application.
Okay, no, I appreciate that. And appreciate you leading off. Good thoughts on those topics. Commissioners, questions or thoughts around the deliberation provided by Commissioner Oath? Commissioner Messner?
Thanks, Commissioner Oath. Appreciate your perspective and your thoughts on this. I'm gonna ask some questions and get your thoughts on I guess the no net adverse impacts first, and then I want to go and ask just a couple of clarifying questions about the threshold piece. So I I like where you're going with the review concept, because I agree. I actually think that a lot of this was developed in the mission change rulemaking, and how we apply it and the clarity of how we apply it matters. And it really goes into a topic I'll bring up later on today, but how we evaluate the different plans that are submitted, how we evaluate applications, and how we apply the rules in our decision-making process is critical, I think, to the success of evaluating and addressing cumulative impacts. And so for me, I looked at it two ways. So, the no net adverse impact standard is something that's been contemplated by different stakeholders. And as I've indicated before, it's one that I think we both use in our variance process, but also one that I think gets applied in different ways in land use processes in a lot of different places. And so I'm comfortable with that standard, at least understanding how to apply it. Now, the question is whether we should apply it or not, I think. And so now, understanding that there are some legal questions about it, I think that that's utilized enough in different applications in land use that I think it's possible to utilize it. I think the question is it necessary to use it or not? I would agree with you that I'm not sure it's necessary to utilize it if we clearly apply Rule 315B3, because I think it gets to the same concept. And so I appreciate that perspective that you bring. And so I guess one clarifying question, or an in application of that, how do we apply that, and how is it clear and transparent that we've walked through all of those steps in our decision-making process, both at the staff level in their review and at the commissioner level in their review, so that we're making findings to meet those different standards of review. And so, for example, in local government land use processes, there's often standards like this, whether those standards are coming from a comprehensive plan or whether those standards are coming from other land use plans. And, in a staff report, you see findings of how they believe or don't believe that the application meets the different criteria that are laid out in those different land use plans. I see this the same way. And so I think my hope would be that if we do apply this concept that you're talking about here, and that's in the draft rules, that there are sections in both the director's recommendation as well as in our process where we're actually walking through those and making a determination individually and collectively whether or not those standards, have been met, and how we made that determination, right? And so I think as long as it's applied correctly, I would agree with you. I think that handles this concept and how we apply it, and does ensure, at least from our perspective, that an application does or does not evaluate and address cumulative impacts as intended by the rules. But I think that there has to be some prescriptiveness on how we apply that, and how we develop the findings in those different sections in two different places, again, at the staff level and at the commissioner level in our independent review of the application. So I guess those are my thoughts on that. So I appreciate your perspective. And then to get back to the thresholds, and I hear you, and I acknowledge, both you and Commissioner Ackerman, the challenges with thresholds, and the whether or not there's data available to do that, and who the agency is best equipped to develop those thresholds. And so I hear that. The one question I have is, there's some proposals that, well, before I ask that, just so I understand, I thought I heard that there was, from a baseline monitoring standpoint, that there's certainly CDPHE processes that require baseline monitoring in order to gain certain permits with the Air Pollution Control Division. I'm still trying to figure out where pre-production activities fall into that and how that gets captured or does not get captured in the timing of that baseline monitoring. And does that need to be something that we consider, not necessarily for developing or determining whether or not thresholds have been hit, but to continue to gather data, just like as Commissioner Ackerman talked about with the different layers for surface disturbance. Is there a hole that needs to be filled for baseline monitoring for pre-production activities that ECMC could help fill by certain baseline monitoring requirements in our rules? So those are my two musings.
Thank you, Commissioner Messner. I really appreciate all of that. And so on the first part, I agree with you. I'm trying to think through, I can see how the staff review of these factors could be memorialized in the director's recommendation. So that could be an additional kind of ask or add to the regulations, would be that, we'd be looking for that to be added. This is a bit where maybe I'll put it back on you. In the commission's review, though, there's not, of an OGDP, for example, there's not like a statement of basis and purpose that goes with that. So I'm not sure how to get at, I think, that point of how do we ensure that we are deliberately walking through those factors and being transparent about how and why we came to the conclusions that we did in each case. So I don't know if I have the solution for that, but I agree with you. It's important to make sure that we are doing that.
So my thought is, and again, 2 independent review processes, but a lot of our rules indicate that we need to look hard at the director's recommendation and utilize the expertise, the referrals, and the consultations that are associated with both the application and the staff's review of the application that's included in the director's recommendation. And so, and our AAGs have clearly indicated that in our decision-making processes, we need to have findings developed by individual commissioners to back up whatever our decision is, whether that's asking for approval or denial or additional conditions of approval or whatever that may be. And so I think that the individual commissioners walkthrough is just that we, in our deliberations and in our ultimate decisions as individual commissioners, that needs to be one other thing that we develop findings for as individual commissioners, as we build our record for our decision making. So that's my thought. And how we clarify that is not necessarily in the rules itself, could be in the statement of basis and purpose, because the statement of basis and purpose should capture our intent, right? And how we intend to apply these rules. But I don't know, we're not going to do a written decision document individually by commissioners. I don't think that's the expectation.
Yeah, that makes sense to me.
Commissioner Shea?
Yeah, we'd be happy. Commissioner Messner, you asked a question about pre-production monitoring in our process, and I'm happy. We have a subject matter expert that's online that's happy to kind of walk through that process for you.
Go ahead.
Yeah, that's fine. I think, again, my question is there a hole? And if there is a hole, opportunity to create additional data by baseline monitoring. So that's the question.
Yeah. Okay. And I think they can talk through kind of the details of the process and then let you all kind of discuss. Okay. Tessa Sorensen, I think, is online.
Hello, commissioners.
Good morning.
So just because it's a new day and a new recording, Tessa Sorensen, Energy Liaison for the Colorado Department of Public Health and Environment. So speaking on behalf of APCD, to answer the questions about that, the requirements for oil and gas activities in pre-production for monitoring is a 10-day, and it's not a baseline, but it is a 10-day monitoring prior to pre-production activities commencement. So on the site. So 10 days of monitoring there, and then monitoring using the same equipment throughout the process of pre-production, and then 6 months afterwards. The 10 days in this case, I say it's not a baseline, and it is not called a baseline. It's the closest thing to what I think you are discussing as a baseline, because it is meant really to calibrate what is the state of the air specifically there for that monitor, for that contaminant or for that pollutant that it is actually measuring for, so that it can be able to see it's like calibrating an alarm, so that during pre-production emissions and our pre-production phase and 6 months after, you could see when things are happening that have changed the levels that monitor saw prior to commencement for that pollutant specifically. Director Fury in APCD, when we spoke in our responses, so I'm just going to repeat some of what she said, did mention that those monitors that are used, it's not for all of the pollutants out there. It's for one set, usually VOCs, but there's other options as well. And that equipment is not the type of equipment where it will record everything. It won't record everything to the best of its ability. That's expensive, difficult equipment to utilize in a very kind of specialized manner. It's not common at all. It's not easy to acquire or to use, and it generates a lot of data that has to be managed as well. I don't think, speaking for APCD, that we could answer your question, Commissioner Messner, about where is the hole. I can tell you that what is required by APCD is, I don't think would have much value in terms of addressing cumulative impacts, so much as addressing potential operational issues specific to the site for early identification and remedy. And that's actually, we've seen a lot of success doing that, where possible issues have actually been addressed very early in the process because of that monitoring requirement. So I hope that answers your questions, and I'm available to answer any further ones if you have some.
Commissioner Oath?
Sorry, Commissioner Messner, I have some thoughts too, but you're unmuted. Why don't I have you go first?
Go ahead.
Well, thank you, Ms. Sorensen. I really appreciate that. And I guess in thinking about this, I think the other piece of information that I'm thinking about is, in addition to kind of the operator specific monitoring that is required by Reg 7, the state in general, and certainly the Air Division in particular, and other local governments do have extensive monitoring networks around the state that are kind of doing some of the more collective kind of, what is the state of affairs in different areas. And then there are, there's mobile monitoring equipment that goes out to deal with kind of localized areas of potential concern. But anyways, I think all of those things together tell us different parts of the story. And I don't know that I know the answer to the question either of, is there a gap that we should be filling here in this hearing? Nothing jumped out to me through the proceeding to say that this is the gap and this is what we ought to be doing. I guess I'll just say that.
So in response to that, Commissioner, and appreciate those thoughts. It's kind of like asking for you to have a baseline of what your health as a human is. It's a difficult thing to measure. It's not measuring just one thing, right? There's a lot that goes on, and it could change based on time of day. It could based on, and that's true of the air as well. It could based on time of day, what the meteorological conditions are. All of that can change. So the ability to say that there's one thing that can be measured, I think you could distill it to this. There's no one thing you can measure in a specific way to give you an accurate baseline for cumulative impacts analysis for air. It's unfortunately not, it's so much more complicated than that. You can't simply do that. In terms of whether CDPHE sees a gap, I don't think we can speak on that in this context. Right now, it's still an issue being considered in terms of how it's addressed in many ways with an APCD.
Commissioner Messner?
I appreciate that and the explanation. I think to refine my question a little bit, as Commissioner Ackerman talked about for wildlife and developing layers of information that will better inform databases to help with regulatory considerations at future dates. That's really my question for baseline monitoring. Is there a gap or a hole that could be filled in this rulemaking that may provide data that could better inform databases so that, as future rulemakings or decisions happen, there's the ability to populate databases with appropriate information or not. And that may or may not be the role of ECMC, but as we are tasked in this rulemaking to consider some of this stuff, that's why I'm asking the question.
Thank you, Commissioner Messner. I think that what I could say is that if there are data needs in that area in terms of air monitoring and the impacts of pollutants in the air, I think that's something that APCD and AQCC are constantly thinking about in all of their rulemakings and all of the regulations. That's always, I think, one of the primary concerns that we are always looking at. So I think that is certainly being done. We have the upcoming rulemaking for, I believe, regs, I think it's reg 7, but someone needs to correct me whether I'm wrong. Sometimes I get the numbers mixed up on there. That is coming up before the end of this year in terms of being considered to open up that rulemaking within AQCC. So I think that it is a constantly evolving process, and we are absolutely the ones, I think, thinking the most about that already on that front in terms of what data is there. And we do receive a significant amount of data to look at there as the Air Division.
Commissioner Shea, do you want to speak to that upcoming rulemaking in any further detail?
Yeah, I can get information for you just so you have all the requests for hearing dates and then the expected. I don't know it off the top of my head, but I can get that and share it with y'all.
Great.
The first meeting, I think, was held. I'm sorry to interrupt, Chair Robbins. Yesterday, I think the first meeting, stakeholder meeting, was held for the Reg 7 rulemaking for Air Quality Control Commission. And the second is scheduled for October 26th. It is for Regulation 7, and it's for ozone pollution reduction planning, and that includes updates to the monitoring section of Regulation 7.
Great. Thank you for that information. We appreciate your being available as a subject matter expert to talk about these topics.
Thank you.
Further discussion, deliberation, thoughts from commissioners? Commissioner Ackerman?
Yeah, thanks. No questions, and appreciate Commissioner Oath. I know that you've been pondering this for much longer than the time that it's been assigned to you, and really appreciate your thoughts on the matter. I just want to reiterate and state that I do agree that thresholds of this nature are most appropriately determined by our expert sister agencies. As with wildlife, I certainly do have ongoing interest in discussing scientifically derived, appropriate, and applicable thresholds. But I really do feel it's imperative that the appropriate state experts devise and support those thresholds if we're to implement them in procedural law. Hence my support of incorporating APCD and AQCC devised and established NOx intensity standards in the forward-looking way previously described by Commissioner Oath. I think that's the right pattern if we're to incorporate those types of thresholds in our regulations. And if CPW and is able to create disturbance thresholds and or CDPHE is able to create further air thresholds, I'm certainly very interested in how we can apply those to the work that we do. But I continue to have trepidation about striking off on that road, ahead of those agencies.
Thank you, Commissioner Ackerman. Further deliberative thoughts? AAG Davenport has visualized.
Thanks, Chair. I just want to touch base, given that I'm charged with sort of determining where consensus exists on particular topics, and specifically consensus in changing what is in the August draft. I'm looking for correction to this statement I'm about to make. The only place where I've seen potential consensus is to the standard that Commissioner Oath expressed in her comments, that if the commission feels that the cumulative impact analysis does not adequately evaluate or address CI, then the rule should explicitly state that the commission may deny the application or impose additional COAs. My listening to the deliberations indicated me that there was consensus around adding that to the August draft, but I'm not seeing consensus or anything about adding anything else in either air thresholds or known at adverse impacts topics to the August draft. Is that accurate thus far?
You want to weigh in, Commissioner Oath?
Sure, I think that's right. I think that the conversation Commissioner Messner and I were having is a really important one, but as I understand it, I think we landed in that there does not need to be a change to any regulatory language, but that it's important for us, and we may want to consider it as statement of basis and purpose language, about making sure that we are applying, we are that staff is evaluating those factors and including that assessment and analysis in the director's recommendation, and that we as commissioners are certainly walking through that individually, but then as a whole, in our decision making, we will be making a determination, but not a written finding with each application. Commissioner Messner, okay, I see you're nodding. I was going to say, if you had any other thoughts, please jump in.
AAG Davenport.
Thank you. I will add a note to include something in the SBP along those lines that you just expressed, Commissioner Oath, and we'll include that in my list of where there is consensus.
Thank you. Appreciate it.
Commissioner Shea.
I just want to follow up on my promise, just so everyone listening can hear. We are doing a request for rulemaking in November in front of the AQCC to make changes to Reg 7. So that will include some changes to the pre-production and production air monitoring requirements. And then that hearing is currently scheduled for February. So February 19th to the 21st is what's on the calendar right now. That's all I had.
Great, thanks. Further thoughts on this matter? All right, Commissioner Oath, thank you very much for leading off this morning. I need a quick break. Let's take 10. Let's return at 9:56. All right, welcome back. Energy and Carbon Management Commission, day 52 on the cumulative impacts in enhanced systems and practices rulemaking. Just kidding, but we will continue to move forward. I believe next we were to hear from staff on the matrix regarding notice. Ms. Trask.
Good morning. Sorry for the delay. I just sat down again. Could you repeat the question or the request?
I thought that we were hoping to perhaps hear from staff with regard to a table on distances.
Yes.
I don't know if you're ready with that yet or not, but that's where we were planning on turning.
Yeah, I do have a table. I believe that it is still under some AAG review that should be wrapped up shortly. Could we circle back to this in a little, I don't know, 20, 30 minutes?
Sure. Yeah.
Thank
So
you. Appreciate that.
we'll circle back to that in 20, 30 minutes. Perhaps then let's, I'm still working on the work that I'm doing. Perhaps then let's turn to the other non-foundational issues that were not dealt with. Commissioner Messner, this was something that you had raised this morning. And I think Commissioner Oath had a couple as well.
Yeah, I do have one. Well, it's possible I'll have more than one, but I'd like to hit one here. Generally speaking, just so you know, there's going to be, I've got 3 identified right now, although I have to be honest, we're jumping around a lot, and so I'm losing some things in my notes, and so I'm trying to keep track. So I may have some that might come up as we go page by page that I've missed in my notes, and so so the 3 are some process pieces after completion that I think would aid us in applying the rules. And then I did want to talk a little bit about some considerations for water quality and reclamation as it relates to cumulative impacts. And I know that Commissioner Ackerman has brought up some topics associated with reclamation, and so I think mine are going to be pretty minor in that, but would perhaps tie into some of his thoughts around reclamation. So I just put that out there, and I don't want to necessarily talk about them all at once. So let me talk a little bit about process here. And so to me, you know, I think that we do a really good job of working together through mission change and all of the rulemakings that we've done to create rules that I do believe are protective. I do think that it's important to continue to build out how we systematically apply those rules to create both clarity and transparency, you know, in the application of those rules, to ensure that in promulgating these rules, they're applied in a way that is most protective. And so I have some suggestions that may, I think, help us in this process. And so some of that was in this pre-application process that I had spoke to previously, and appreciate the commissioner's consideration of that thought process in the pre-application meeting, the pre-application process. But then the completeness process through technical review and then ultimately to our review, I'd like to make a few suggestions that could get incorporated. Again, like we talked about with the cumulative impacts assessment review or analysis review, doesn't necessarily have to be baked into the rules itself, but certainly, in my opinion, should be incorporated into the statement of basis and purpose to better guide and kind of structure that process. And so, you know, in my opinion, and based on the experience that I have had with different land use review processes, you know, what we do here at ECMC in reviewing these applications is very much a land use review process. And so I think it would benefit us to apply some of the experience and expertise of local government land use processes that have been, you know, tried and true over decades and decades as they, you know, have implemented these land use processes. And so in our process, we have applications that upon completeness go through a technical review process, and through that technical review process, we have different consultations that are being performed that help inform the review of that application and evolve that application to a point where it gets a director's recommendation and it comes to us for review. I think my suggestions would be that there are internal and external reviews. The external reviews happen in a relatively formal manner that internal reviews seem to happen in a relatively informal way, at least the way that we see it from our end as we're trying to review it. And I think the importance, and this all builds up to the importance of the director's recommendation and building to that director's recommendation and how we can utilize that in our independent review to best apply the rules at our stage. And so my ask and my question to the commission, if they would agree, is to create a little more formality in our internal review process so that we've got clear internal referrals that happen during the technical review process that clearly identifies the eyes that get placed on the application as it goes through our process and utilizes the expertise, which I want to preempt this, which I know this is happening internally, but I think that we have to formalize it so that we have a paper trail that builds to that director's recommendation and takes some of that burden off of the location assessment specialists and allows them to be the gatekeeper, the coordination of these referrals so that we are fully utilizing the expertise of the agency in reviewing applications to get it to the director's recommendation. And so different departments, whether it's the cumulative impacts unit, whether that's the engineering unit, whether that's the environmental unit, which has both reclamation and environmental, whether that's the financial unit for financial assurance, whether that's the compliance unit for operator compliance. What typically happens in a land use process is those agencies internally, those units, departments, all get referrals for particular applications and ask them to get eyes on that application and provide a memo or a report for suggestions or modifications or considerations, you know, in that application, depending on that particular unit's expertise. Those referrals get distributed to the planner or the reviewer, and then to the applicant, and that's through the technical review process how that how that application evolves until it eventually gets to the director's recommendation. So again, I know this is all happening informally, but my ask here is that we recommend that there be more formality to that includes memos or written communication that goes from these units within ECMC to the planner, the location assessment specialist that's compiling and coordinating this application, and that is included in the record and then quoted and included in the director's recommendation as applicable in order to help develop the findings to make a determination of whatever the recommendation is from the director. And so whether that's a recommendation for approval, denial of additional conditions of approval, to have these sections in there that help identify the different departments that are making certain recommendations and are utilizing the expertise of the whole of ECMC in reviewing these processes, I think aids in clarity and transparency to the public, to the operator, and ultimately I think helps us make good decisions because we, I think, would have a better perspective as to how the staff is reviewing an application and applying the different standards and, you know, how they're utilizing their expertise and determining their ultimate recommendation to us. And so again, this isn't a shift to the rules because I do believe that the rules are protective, but it aids in our clarity and transparency and consistency in our decision making in these determinations that we're making by having that more formalized and more clear and have a stronger paper trail associated with that you know, enables us to make better decisions, you know, at the commission level. And so that's the internal piece. And then the external piece, which I think is really important as well, is, you know, CPW and CDPHE our primary external consultations. And I do really appreciate that these independent agencies are providing consultations and, you know, are providing that formal consultation to this process, you know, and a clear paper trail is incorporated into both the record and to the director's recommendation from those consulting agencies. And I think that also, you know, is important in helping us make a determination and utilizing the expertise of our sister agencies to determine whether it's protective of public health or whether it's protective of wildlife and environmental resources. And so, you know, continuing that formality with that through the process so that we have a clear record, we have clear transparency and clarity, and that the director's recommendation is developing findings that bring in that different levels of expertise. And so that's my request. And again, I want to make sure that it is understood that I do believe that this is happening internally, and I do believe there is some structure in place, but I'm asking for, I guess, more clarity and more structure so that it is built out in a way that more closely replicates the processes that are typically seen in a local government planning process and developing findings for the recommendation so that we can ultimately utilize that in the most efficient way possible to make decisions at the commission level. So I have lots of specifics, but that's the concept. And so I wanted to put it out there because I do think, as I indicated with the cumulative impacts analysis discussion we just had, that how we apply it is important and is a part of this rulemaking because it is applicable to how we evaluate cumulative impacts, minimize adverse impacts, and apply the standards that we're discussing in this rule.
Thanks for the comments, Commissioner Messner. I noted that Ms. Trask had visualized and now she's gone, and AG Davenport has visualized as well. Did you want to weigh in on this?
Asking a clarifying question, if I might, Mr. Chair, for my own purposes of keeping track of deliberations. Commissioner Messner, I'm wondering if what you're suggesting, excuse me, is more along the lines of kind of like an internal, public facing ultimately, but still kind of an internal ECMC process / guidance document rather than rule-based requirements. One of the benefits of that type of document rather than rules, we wouldn't have to go through rulemaking to create it or change it. Of course, that type of document couldn't add substantive requirements or do something different than our rules already provide. But just curious if you're suggesting a change to the August draft or if you're kind of leaning more toward the kind of internal process document that I described.
So my intent on bringing this up is to have it like we talked about with the cumulative impacts analysis, somehow captured in the statement of basis and purpose as to the intent of the commission and captures the conversation that happened during this rulemaking as to how these rules may be applied from a procedural standpoint. And so understanding that may also include guidance, but also understanding that from a commissioner level, this is the procedural tool that commissioners have in order to provide intent or guidance to the application of the rules.
Thank you.
Mr. Chair, if I might add a little bit of context.
Go ahead, Ms. Trask.
Commissioner Messner, I just want to clarify sort of what the current internal process looks like. When the operator submits the initial hearing application for the OGDP, that hearing application is reviewed by different units, staff in different units. Specifically, there is an engineer that reviews some of the spacing and downhole information in the hearing application. And then someone in the permitting staff, not the location assessment staff, but the permitting portion of that team reviews the rest of the hearing application to make sure that it aligns with all the Rule 500 requirements as well as the geologic testimony review. Those reviews are documented on paper and are available in the e-filings system under that docket number. So that is already part of the written record. Both any comments that those staff members provide to the operator and any response from the operator in fixing that hearing application. As far as the Form 2A, 2B, 2C, sort of the more technical data aspects of the OGDP application, I will say it is somewhat rare for the location assessment staff to ask for additional review from another unit. So the location assessment staff is trained to review the whole application from top to bottom. We do have a couple of location assessment specialists who do have specialized expertise, particularly on the noise plan, because that one is sort of its own unique beast. And so there are specialists within the location assessment team that might be called on to provide some additional review on a noise plan or a light plan. Very occasionally, the location assessment team might request assistance from one of the environmental protection specialists in the environmental unit to review a waste management plan that might be different than we've seen before. And occasionally we might request assistance from someone on the reclamation team to review an interim reclamation plan or a topsoil plan or a stormwater plan. But that engagement with other staff outside the planning team is rare. I think there is room for us to create sort of that internal SOP. Once we can develop that, we can make that public if that adds value. And if the commission would like us to start sort of documenting those instances where the location assessment group seeks expertise outside their own unit, we can document that and add that to the record. But I do think that is a small percentage of OGDPs. I don't think it's a very common practice.
Thank you for that, Commissioner Ackerman.
Thank you, and I appreciate this discussion and agree that it's not a regulatory issue. So thanks for specifying that. And I also appreciate the extensive technical work that staff does on every single project. I do like the idea of being able to see the process work as much as possible, but I am a bit worried about bogging down the process as we continue to seek efficiencies. So that's certainly something that I would want us to be cognizant of with too much formalization of processes. I do think we're seeing some of those issues come up if in the director's recommendation, if they remain unresolved between the director and an operator. A recent example of concerns over an informed consent issue was specifically raised in the director's recommendation. So I do think some of those anomalies come up. But my main reason for chiming in here, Ms. Trask, if we do talk internally about tightening up those protocols and thinking a little bit more about them, I think we could benefit from a discussion of standardization of timing of the release of the director's recommendation to us and the public. And so if we do go down that road, I would ask that we consider that issue as well.
Noted. I can work up some thoughts on that if you like.
Further feedback on this issue? Commissioner Messner, did you want to weigh back in?
Yeah, I mean, I'll close out my thoughts. So as I indicated before, I understand that there's some level of internal process that is occurring, and to me, and that there are elements that do get included in the director's recommendation. I think the ask here is that while I think it's a lot to ask, one staff person like for example, in a planning scenario from a local government, there are planners that are experts in planning, but they're not asked to be experts on all the other things in the different departments. And so utilizing some expertise, as applicable to different entities, different units, I think adds to the work and of reviewing these applications, adds to the expertise in reviewing these applications, and helps us create clarity, expertise, and transparency in our review process, and to have that so that it is internal referrals go out, there's a review, they come back in to the location assessment specialist, they get incorporated, they get built into that director's recommendation, and just adds to that consistency. There is I think it would just help us in our review at the commission level to be able to have that clarity. And it would also help, as I'm hearing feedback from the public, in better understanding how we're applying the rules, where we're applying the rules, what standards we're applying in the rules. And so that we've got a way of showing that, yes, these rules are in fact protective, and these are the steps that we went through, and this is how it's documented through the process, which aids in transparency, aids in clarity, alleviates a lot of questions about our process, provides, openness to the people that are interested in what's happening, and then ultimately helps the commissioners understand the perspective and the review that happens at the staff level in developing the director's recommendation, which in turn aids us in our decision making at the commissioner level. And so that's still the request here. I think the timing of the director's recommendation, as Commissioner Ackerman brought forward, is also important and also aids in the review to enable us to make the best and most protective decisions that we can. And while I appreciate that there's some pressure for efficiency and timing of review, to me, the most important thing is to ensure that we're reviewing these applications in a way that ensures that they're protective, and we're cognizant of timing, but that not be the driver, that the driver be that we're reviewing these in the most robust way that we need to in order to ensure that they're protective. So I understand also that this is a little bit outside directly of what we're talking about here, but again, this is, as one commissioner appears the opportunity to be able to share this and have a conversation about it, because what I'm talking about in some respects here is internal and separate from what this commissioners do on a informal basis with staff. And so that's why I'm bringing up in a rulemaking.
Ms. Trask?
Thank you, Mr. Chair. And thank you, Commissioner Messner, for clarifying a little bit. I would hope that, well, let me back up. When the location assessment specialist is assigned to an OGDP and commences their completeness review, that completeness review has evolved quite a bit since mission change. We've sort of test drove a couple different process options. We've worked with COGA and industry on what works best for individual operators, what works best for staff. And I think that where we've landed is a pretty good process that works for staff as well as industry. That process is that when the location assessment specialist is assigned to the OGDP, they actually conduct a very thorough technical review. It's not sort of a, is this attached? Is this attached? Is this attached? The specialist is actually doing the technical review during completeness. As they identify errors or omissions or things that are confusing, the location assessment specialist indicates very clearly on an Excel spreadsheet. I don't know if you've looked at those spreadsheets, but indicates very clearly on an Excel spreadsheet what information needs to be revised or added or fixed or deleted or whatever. That once that spreadsheet is completely filled out by the specialist, it gets sent to the operator. The forms get pushed back to draft, and the operator is requested to make whatever revisions they want to make on that application. The operator resubmits the application. The specialist then re-reviews the application, sort of checking to make sure that all the things they had originally identified as incomplete or inconclusive, they check to make sure those things have been resolved. If everything looks good, then they pass completeness on that application. That spreadsheet with sort of staff's initial findings, and the operator's responses, and then staff's follow-up responses. That spreadsheet is PDF'd and attached to every Form 2A. So that level of review or that documentation of staff's technical review, I think is really clearly indicated in that attachment on every Form 2A. That is part of the record, and that is available for the public to view as an attachment once the application has passed completeness. So I think that the process that has evolved in collaboration with industry over the last couple of years is a good process and does provide some of that written documentation of how staff is applying the rules in their review of the application. Hopefully that's helpful. We can certainly, I don't want to speak on behalf of the permitting manager, Ben Frizzell, but Ben and I can certainly have additional conversations about where we can improve the director's recommendation for additional clarity. I will say that Mr. Frizzell has been working the last few months very closely with a third-party contractor who is helping further streamline the permitting process and answering some concerns that the commission has received from industry, from other stakeholders, from public comments about our process and making that process better. So there has been over the last few months a really strong push to find sort of where are the information gaps and how can we plug them. I anticipate there may be some additional tweaks to the permitting process as a result of that collaborative effort. But if there is something specific that you'd like to see either added to the application process or added to the director's recommendation, I am happy to hear of it, and I imagine Mr. Frizzell would also like to hear your thoughts.
Thank you, Ms. Trask. So appreciate the response. Do understand that the spreadsheet is in there, have reviewed the spreadsheet on every application. Do understand that the location assessment specialist is making a lot of these reviews and determinations. Do understand the level of expertise that's within our location assessment specialists. Continue to think that the referral process in lieu of the current process is a tried and true process that I think is a clearer and a more robust process. But those are my thoughts, and that's not anything against the process that's been developed to this point. But do think that there's tried and true processes from a referral process, and that could aid us in our review and application of the rules. So that's my thoughts, and so thank you for that.
Others desiring to weigh in on this issue? All right, where do we go next? Commissioner Messner, you mentioned you might have one or two others.
I do, but I think Commissioner Oath has one, so I'm going to defer to her.
Spread the wealth. We'll go to Commissioner Oath.
Sure. Okay. I think mine are fairly discrete type issues that I don't think got captured so far, but were in my notes of a couple of additional changes I wanted to suggest. So 350 Colorado made a number of suggestions for kind of some plain language materials to be provided by operators in a number of different contexts. And I think as we're thinking about best practices and ensuring that the public is meaningfully understanding kind of what is being proposed, that those can be really helpful. So particularly 350 Colorado's suggestions to require plain language summaries of the Form 2B, Form 2F, and the cumulative impact analysis, I think would be particularly helpful. That's it for that one. But would look for thoughts.
Thoughts, commissioners? And or staff? Commissioner Messner?
Thank you, Commissioner Oath. I would agree. I maybe shed a little bit of light on, from your perspective, like what does that mean? Like how does that look? From like a cumulative impacts analysis, and because I agree with intent, I'm just out of curiosity, I'm trying to understand, what does that look like, and who's doing the plain language? Is that an expectation of operators? Is that an expectation of staff in their review of it? Is that something that we need to consider as we are deliberating on it? Like how do you see that?
Yeah. Thanks for that question. I would see it as an expectation of something that the operator would put together, not an additional burden for staff. And really is just intended so that members of community who are involved in the process then have kind of, like a 1-page kind of summary of what I expect to be a very, the cumulative impact analysis is going to have a lot of very technical, quantitative and qualitative information in it. And so kind of an overarching summary of kind of what is contained within it, for example. And similarly, like for the Form 2B or Form 2F, it's sort of like what is the incremental impacts that an operator would be proposing, just kind of a summary of what that looks like.
Seeing no real dissent here, I think we will instruct AAG Davenport to put it on the list. Is that fair?
Right.
Chair, may I?
Go ahead.
Thanks. Instruction received. I'd had a question. I understand plain language summaries of the Form 2B, Form 2A, and CI analysis process to be prepared by the operator on an OGDP by OGDP basis. Is that correct so far?
Yes, but to make sure that I heard that the second thing you said was Form 2F. I thought you said Form 2A.
Oh, Form 2F. Okay, yeah, I did say Form 2A. And that would be rule-based, correct?
That's
That'd
right.
be in the rules. When would that be provided?
That is a good question. Let me think about that. I presume at the time that those documents are submitted to ECMC. But let me think about that piece.
Okay, I'm going to put timing TBD
Yeah, okay.
into the document, the summary document.
Okay.
Thank you.
Yeah. Okay.
You want to keep going, Commissioner Oath?
Yeah, the next one would be in 315 B2 GG3. So this is in the cumulative impact analysis, where the proposed location, is it within proximity, some additional information to be provided, and specifically this is some additional information kind of diving into the EnviroScreen score, just a very small tweak to the language in 3. So in the August draft, it indicates, identification of the proposed BMPs or ESPs to be used at the proposed location that address the issues that exist as a result of the EnviroScreen score. And I just think that's not accurate. Issues don't exist as a result of the tool of EnviroScreen. So it would just say that exists as reflected by the EnviroScreen score.
I like that. Anybody with concerns? No concerns, direction given to AAG Davenport.
Thank you. The next was in their opening remarks, the staff had flagged a number of cleanup items. I have not gone back to see how relevant those are based on kind of our deliberations and changes. But I had noted that I wanted to provide some direction that yes, we want to see some of those cleanups. I think maybe in general, that may be a general directive or authorization to staff to do cleanups and conforming changes based on kind of our deliberative thoughts and direction that we provide. Just want to make sure that we're clear that we are providing that latitude and request. Yes, AAG Davenport.
Thank you. That's part of the standard process for staff and the AGs to do that. I do think that's also built in to the extent the commission at some point goes through the draft or the August draft page by page after staff has had an opportunity to respond to commission direction. The standard process, the one we followed before, is at some point we do put rules up on the screen in hearing and go through those rules as sort of a final review. If that's the commission's pleasure, it can also be done at that point as well as sort of, but staff will do that and the AGs will also do that. Just for your information, Commissioner.
Okay. Thank you. My next one or two were related to 316C, so the enhanced systems and practices, but I think Commissioner Cross was leading on that, so I've been kind of holding those until we talk about that section more generally. Is that still the case? Okay. Great. And then the last one that I have was we got a couple of different proposals around kind of more clearly articulating the hierarchy criteria in is it in 315B. I wasn't quite prepared yet this morning to sort of synthesize which of the various proposals I thought made sense, but I'm happy to kind of take a close look at that. But in general, would be in favor of providing some specificity there, provided other commissioners are in support of that as well.
Commissioner Messner.
Thank you, Commissioner Oath. That is on my list, and so thank you for bringing that up. I think generally speaking, and you know, again, I think we could go through it ourselves, or we could make a kind of a blanket statement that, you know, where applicable in the rules, clarifying, you know, the utilization of the mitigation hierarchy and how that mitigation hierarchy gets walked through in, you know, the technical review process and the director's recommendation, and in turn, you know, ultimately we'll have to do that as well in our process. But then that also signals to operators in the development of their applications that that should be something that they walk through as well in their, you know, in their showings of, you know, the different elements of the application. But that emphasis on applying the mitigation hierarchy and how it should be applied, I think, needs to be core to how our rules kind of build up through the process. And so I think there were some good recommendations that came from a number of different stakeholders on that, and so fully support that that philosophical, I guess, suggestion to the rules. But if necessary, I think we could be more granular to it.
I like that suggestion of just providing kind of that general direction if AAG Davenport and staff feel comfortable with just that as a general request that be considered in an updated draft.
AAG Davenport.
Thanks, Chair. I have a question to clarify my own understanding. Are we talking about rule language or are we talking about more kind of SPP language?
We are talking about rule language, so I know that it showed up in a number of the proposals, just to be very clear about, first avoid, then can avoid, minimize, and mitigate.
Okay. Thank you.
Great. Others to weigh in on any of this or anything new?
Mr. Chair, I'm happy to bring up my other couple of topics if no one else has anything else. If we
Go
want
ahead.
something else, that's fine as well.
Yeah, go ahead, Commissioner Messner.
So there was some suggestion about including in the cumulative impacts analysis a section on water quantity in addition to water quality. And I tend to agree that that should be a consideration in cumulative impacts of water quantity. I think that there's some suggested red lines by Western Colorado Alliance on that. I'm not sure the red lines have it right. But I do think that some evaluation of the cumulative impacts of water quantity is something that would be valuable to include in the cumulative impacts analysis. There was reference to the Produced Water Consortium in the red lines by the Western Colorado Alliance. I don't think that that reference in there is necessarily appropriate. I do think that the Produced Water Consortium will continue to make recommendations to the Commission on topics related to water quantity and reduction of freshwater use in oil and gas activities. An acknowledgement of that in the statement of basis and purpose could be appropriate, and certainly we'll be having a produced water rulemaking later on in the year where this could be further discussed. But I do think the suggestions to Rule 314B3 by the Western Colorado Alliance for Roman numeral 4AA, which is evaluation of proposed water use and for pre-production and production activities, a description of the impacts to any freshwater use on water resources, both within and outside the impact area, and a summary of best management practices intended to reduce impacts for freshwater use. That I think is good. Maybe it's a little more questionable potentially to include within and outside the impact area, but certainly within the impact area, I think makes some sense as an additional evaluation of potential cumulative impacts, and so would suggest at least a discussion on that to get other commissioners' thoughts of whether that's something that should be included.
Commissioner Oath.
Thanks for bringing that up, Commissioner Messner. I don't disagree that it's certainly very important. My thought, or I guess, or even question, and I don't know if it's a question to you or perhaps AG Davenport, but I just want to make sure we're not getting out beyond our scope of this, right? So the way the cumulative impacts is defined, which I think comes from statute, but we're again looking for some help here, doesn't seem to encompass water quantity, but just looking for some thoughts on making sure we're on solid footing if we add this in.
AG Davenport.
Thanks, Chair. I think the question goes to statutory authority and jurisdiction to address water quantity. And okay, I was wondering if it was scope of the rulemaking. I'm gonna punt. I need to go back. I haven't had a minute to look at the definition of CI, and so I need to punt rather than sort of say something that I'll have to come back and correct later. So if you could give me maybe over the lunch break or something, I can come back and look at this and come back and answer that question.
Fair enough. Is
Thank
that
you.
okay?
Yep. Appreciate the grace on that one.
Commissioner Messner?
Yeah, that's fine. Appreciate that. And I think that's a fair question, Commissioner Oath. And then I did have, there's I guess a question. So Commissioner Ackerman went around the reclamation piece. And you know, we've heard a lot of information from a lot of different commissioners and a lot of different stakeholders in the last few days. And so I think as I was looking at my notes this morning, I may have forgotten a conversation we had, but as a reclamation expert, I wonder how you feel reclamation is captured in the cumulative impacts analysis. Because I can't remember, I guess, the conversation on that one. And so wanted to perhaps just get my memory refreshed.
Yeah, thanks. Good question. And I'd have to go back and look at reports to give specifics on how I think it's captured. But my general impression is not very well, because we don't do a great job. Well, we don't do really a job at all of mapping reclamation. And while we do keep track of reclamation status, both interim and final reclamation, I certainly think we could, we have a lot of progress to make on cumulative impacts reporting associated with reclamation. So that's a broad statement, but certainly happy to talk about it more.
And did you have suggestions for inclusion in this rulemaking on things that may help us do that? Because that's, I think, where I missed it in my notes.
Not necessarily, but kind of peripherally, you know, as we talked about surface use improving our surface use disturbance mapping tools. I think that would go a long way towards being able to evaluate reclamation for the purposes of cumulative impacts reporting and analysis. So maybe we can touch on that when we get to Regulation 904 on the walkthrough. There's a couple other things that I want to talk about in there. But I do think that it's important, very important, and I know staff feels the same way. That's a very important piece of our cumulative impacts analysis and reporting. And so if you don't mind, I'd be happy to maybe defer a little bit when we're going through the draft.
Thank you for that, Commissioner Ackerman. I would really appreciate that, and certainly appreciate your expertise on the topic. And so thanks for that. So my last one, and this is again philosophical to an extent, but I think as I've been in this seat and applied the rules, I can't be appreciative enough of the quality of the statement of basis and purpose that was developed during the mission change rulemaking to both help me recollect, you know, the decisions that we made and the intent for the application of the rules and the mission change rulemaking, and the level of detail in that statement of basis and purpose, I think, was exceptional. And, you know, I think I would hope, you know, as we've got 3 new commissioners since that time, it's helpful in your understanding and application of the rules as well. And so I guess my hope, and I'm not, there's not a criticism because I know we're just in the middle of this process right now, but my hope is that because this is also a detailed and challenging rulemaking and topic, but that the conversations that we're having here, the decisions that we're making, and the intent that we are landing on in this cumulative impacts rulemaking, I hope is captured as robustly in this statement of basis and purpose as the complex topics that we work through in the mission change rulemaking, to both help us in our decision making and applying these rules over the next few years, or any other commissioners that may follow us. And so, so that's just a thought on that. So that's all I have right now. Thank you.
Thank you, Commissioner Mester. Appreciate the comments and thoughts. Commissioners, I've been chatting with staff. They need some time to finish up the table. I need some time to talk with them about some of the work I'm doing. I'm going to call for an early break and give everybody a time to collect their thoughts. And let's return at 1 p.m. to finalize today's deliberative thoughts. Welcome back. It is 1 o'clock on September 25th. This is the Energy and Carbon Management Commission. I'm continuing our work on the cumulative impacts rulemaking and the enhanced systems and practices rulemaking. We got a busy afternoon ahead of us. I'm going to dive right in. I have been assigned setbacks, DI protections, and CIC. We'll start with the recognition that the language of the statute provided that the commission is to create protections to DI similar to the 181 protections that occurred around public health, safety, welfare, the environment, and wildlife resources at section 2.5. This has been looked at in a couple of different fashions. First, we had a June draft that contemplated this direction be accomplished through a revised setback, that any proposed oil and gas location within 2,000 feet of a residential building unit in a DIC must contain 100% informed consent. Following the release of that draft, we held a work session, and I requested the parties brief the efficacy of that approach, but also brief alternative methods to achieve the statutory goal of ensuring protections to residential building units in disproportionately impacted communities. I want to thank the parties for their thoughtfulness and their explorations into how to achieve the protections to DI placed upon ECMC by the statute. I have had opportunities to visit with all sides on this issue and appreciate the thoughtful approaches that have been advanced. These discussions have led at least this commissioner to an alternate approach to protections to DI. I have, and will share now, a new setback for proposed oil and gas locations within 2,000 feet of an RBU and a DIC. Now, I don't do this very often, but let me try to share my screen. All right. Can someone confirm that I've successfully shared a screen?
Yes, you have.
Yeah, okay, thanks. All right, so this is 604. This language here is our current language with a B. So if you're within 2,000, between 500 and 2,000, then here are your 4 outs. This is not changed. And then the substantial equivalence is this piece here, and this hasn't changed either. So these 7 are part of a substantial equivalence discussion around if it's within 2,000 feet of an RBU outside of a disproportionately impacted community. What I'm suggesting is this new language, and it's not redlined, so I apologize. For oil and gas locations within 2,000 feet of an RBU or high occupancy building unit within a DI community, the commission will base its consideration of substantial equivalence on the criteria up here. So the previous criteria that we're familiar with, as well as new criteria that I'm going to daylight below. However, in order to qualify to try to make a substantial equivalence finding, you first have to demonstrate the following. And this is AA, BB, CC, and DD. The operator has made good faith efforts to obtain informed consent and provides a summary as to why informed consent could not be obtained. The ALA required under 304B2 demonstrates the selected location avoids, minimizes, and mitigates adverse cumulative impact to DI communities. The information and analysis at GG demonstrates the operator has analyzed the EnviroScreen score and has employed BMPs and enhanced systems and practices sufficient to avoid, minimize, and mitigate adverse impacts to identified community vulnerabilities. And the oil and gas location and design and any planned enhanced systems, practices, BMPs, preferred control technologies, etc., also do the hierarchy of avoid, minimize, and mitigate. Then the new criteria for substantial equivalence determination, if this has been, if the commission, basically the commission making 2 findings. One, this is done, and then it's looking at this additional criteria that is really tailored to DI communities. This AA speaks to informed consent. which is a little duplicative of the previous informed consent. The summary of the documentation of outreach to the residential building unit owners within 2,000 feet. That's this. A written summary of any operator or tenant's comments back. Consideration of the number of informed consents and how many were obtained and were not obtained. This is the information at DGG, and this was part of the August draft. And this cross-reference and summary speaks to specific measures taken to avoid, mitigate, and mitigate. It speaks to that table of the EnviroGreen score. It speaks to the analysis of what you're done to deal with that. And so that's that cross-reference. And then finally, a description of any voluntarily executed community benefit agreement governing the operator and the owners and tenants of the RBUs within 2,000 feet of the working pad surface. And then I've got some language here. The community liaison will assist, but will not actually negotiate the document, but will help folks understand how to do this. All of this stuff is volitional. It's something operators will provide. And so under the substantial equivalence, we'll take into account these things. We'll take into account the original 7. And then we're also taking into account this demonstration here. And then finally, as part of the notice of the hearing, the operator will provide non-consenting owners or tenants additional information so that they can make sure that they have an ability to be involved in the work. That's part 1. Part 2, and I'm going to post all this. As part of the discussions that I had in developing the opportunity, let me stop screen share. I had explored whether to include mandates of the enhanced systems and practices to qualify as part of substantial equivalence. Rather than approach that piece as part of substantial equivalence, and with due respect to you, Commissioner Cross, because the ESPs are on your list, I made some changes to the ESPs and basically making ESPs a requirement if the location is within the DIC. So let me start sharing again. Just set it right here. That'd be great. My lunch just got delivered. Okay. Basically what I've done here is if you're within a DI, all new oil and gas locations subject to Rule 316, the operator will implement the following additional systems and practices. And this is the 4 or 5 that were in our current rule, but they were all under a where practicable standard. So I've made them mandatory, except these 2, produced water and electrification. And I make them down here as part of a where practicable. So here's the language on practicability here. And that's because those 2 are operators desire to do them, but at times it's not appropriate or not practicable to have them done. And then I added some language on the practicability assessment that's in our current rule here to explain the non-applicability of these 2. You got to make a showing as to why. That's part 2. Part 3, I suggest the creation, and this is with regard to DI protections. I suggest the creation of a new rule. I'm calling it Rule 317 because that's the next rule on our 300 series that's not being used. And what I suggest we do in that rule is we collect or at least cross-reference all aspects of the new protections to DI that are contemplated in this rulemaking. One of the things that I've heard and one of the concerns I've got is while I believe we've got protective mechanisms within our rules on DI, whether it's from the development of the community liaison, whether it's the development of that GG stuff, et cetera. One of the problems is you have to kind of stumble through all the whole 54 pages of rule sets. And so I believe creating one rule that either captures all of the protections to DI will establish a understandable position for ECMC and its stakeholders as to how it is that we are protecting. So I developed this rule. I've got this 317 developed, but I'm waiting to kind of get a sense of where we land on all the protections until I share that, but I'll share that as well. So with this provision of this information, I'm happy to take questions from commissioners. I also believe it would make some sense, in AAG Davenport, if you don't mind visualizing, because these are new ideas, new concepts, it might make some sense for us to allow for a very small window of feedback from our stakeholders that are interested in this. I would suggest anybody that's interested have an ability to provide a one-pager by close of business next Wednesday. That's a week out. And that'll be ahead of when we reconvene on the 8th. So that's what I've got. And I'm happy to make sure this all gets posted. Commissioner Cross and then Commissioner Ackerman, or Commissioner Ackerman and then Commissioner Cross.
I suspect Commissioner Cross may have more questions than I. I know that he's been looking at this carefully as well. Mine was just a clarification, Mr. Chair, on you didn't address CICs, but I'm not sure if we wanted to talk about that at a different time or if it's related.
It is related and it's on my list, and thank you for that. I believe that with the protections of this proposed setback, with the protections of all the other things that we're doing, and given the feedback we've received around the inclusion of CICs, it's this commissioner's perspective, we no longer include CICs and we just work with DICs and the parameters around some of the stuff that I just pointed out. So thank you for that clarification. That was on my list and I just missed that note. Commissioner Cross.
Thank you, Mr. Chair. And I think it might be easier if we can bring up the language again, so I make sure I'm getting.
Which one?
So the 604 aspect of it.
Okay.
I think at the very end there is a good place to start. I did want to ask one question, and I'll admit it may be a premature question given where we're going next. But as we're looking at a notice piece within the substantial equivalence, I'm wondering if this can and will be addressed in our notice matrix that we're bringing up as well. Looking at some of it, I know we have, for example, a community liaison description here. I know that's talked about in 224 with respect to the duties, but just some of the information to be provided. And it even mentions as part of 303E, and I'm wondering if it, once we see the matrix, if it can or will be in there and maybe duplicative.
Yeah, I think it's a little bit of a chicken or egg sort of thing, Commissioner Cross, and so I do believe that isn't appropriate for our discussion next. I think I just noticed that the notice matrix is now in our email box, so we'll be able to move to that next.
Okay. And then up a little bit, it had some discussions about the BB here. And I wanted to make sure I clarified one part of this. In BB subsection 2 talks about summaries of all communications between the operator and owners or tenants, providing date, nature of communication, all participants to the communication. And I guess as a clarification, are we trying to identify names of people here? Are we going to look at confidentiality things? I know that I don't want to presume everyone's going to be okay with their name being submitted to something.
No, I think that's a good point, Commissioner Cross. And it's not my intent that we're, calling out names. I know there's a lot of discussions that go in to these things, and we may want to adjust, like some of this information here. This is just a starting point. And so, but I think I think the point you're making is that we want to facilitate and encourage good dialogue and discussion on informed consent. And that might inhibit it if we've got calling out of names, et cetera. But I just wanted to have some documentation of what the outreach was so that we can ensure that folks feel that the engagement is meaningful.
Okay. And I appreciate that. I know sometimes now we talk about it being listed as RBU1, and we spoke to the owner. They didn't sign informed consent, but had no objections, sort of thing. And so I just wanted to make sure the intent was not something more specific.
Yeah, and I may need to fiddle with the language a bit to make sure that we capture that intent, but I appreciate the point.
Okay, and then up a little bit further as it goes from, again, B4, B1 to 2, maybe. So in B4B, just above that, you kind of have the standard again, and you mentioned looking at the standard that we currently use above. So the commission will base its finding of substantial equivalence on that criteria and information provided. And then so you start to list the information that will be provided below, and then
it starts here.
Yes.
And going down.
Yeah, and so up just above that, before where it switches, I just want to make sure so from sub point 1 there, so we have the standard right above it that it will base its finding on, but then in subsection 1 right below it says the commission will not make a substantial equivalence finding under 604 B4B unless. And so I'm curious about that language, because the first part seems to say, all right, here's the standard we're looking at, the discretion we're providing, and now it's more of a black and white sort of almost starting from a negative aspect of it, of there won't be substantial equivalence unless this is shown. And so I'm curious about that part of the language.
What I was trying to do here, and I'm happy to have further dialogue on it, was establish that this information is generated that then allows us to get into the finding based upon all the information that's down below, so that there's good faith efforts to obtain informed consent. The ALA shows that this is going to hierarchy against DI communities. The EnviroScreen does the same thing, hierarchy as to identify community vulnerabilities, and that there's a showing of these things on a hierarchy level as well. And I'm interested in dialogue, and again, I've developed this after having discussions with a number of different stakeholders. I sort of think this 1 and then this 2 are likely to happen at the same time to us, but that we probably need to make this finding first and then looking at this. But I'm open to dialogue on that. And I'll share these documents with you, with my fellow commissioners, and you can work through them and help us understand how we get to the right place on this new concept of a substantial equivalence to DI communities.
Okay. I appreciate that. And yeah, I think in looking at it, I think I'm 100% on board with the type of information shown, especially the additional information in the DI community. I think my biggest question, other than the clarifying ones I asked, was just kind of it seems to change the standard a little bit between B and then B1.
Fair. Other commissioners with questions? And I can't see everybody, so you're just going to have to yell or pop up.
Chair Robbins, I have a couple questions, and appreciate your work on this. Appreciate the way that it's structured, and appreciate that you've developed the findings and then the areas of review. I think that helps with how it gets applied as I've talked about with other things. And so I think that's really helpful. It's hard for me to read that quickly on the screen. I'm on a small screen, and so I'm having a hard time reading it. But I didn't. So one question that I have is the applicability of this to locations proposed with RBUs inside 2,000 feet in comprehensive area plans seeking substantial equivalency, and seeking preliminary siting, not substantial equivalency. Do you anticipate this applying during a CAP review in the determination of substantial equivalency, or is that how does that work?
I don't know that I've figured that out, Commissioner Messner, and I'd love thoughts from commissioners about that aspect. The cap with preliminary siting still remains in play here. If you're within 2,000 feet of an RBU, but it's not part of the, it's not within a DI. So I think maybe what's best is let me share the language to all commissioners. And what we may want to do is put a pen in it and hold questions until after you've had a chance to sort of thoroughly digest this. And then we could come back to it later today or tomorrow morning or something like that. Because I really do, I mean, this is one commissioner's thought product on this. And I really do relish my fellow commissioners having a chance to think through what is admittedly a new idea. Others with thoughts at this point? Otherwise, what I'm going to do is I'm going to make sure that I get this over to hearings manager Thomas so he can get the ideas out to all the parties. Are you guys, Commissioner Oath?
Sorry, thanks, Chair Robbins. So first, also want to echo the thanks to you for taking on this important part of the rule, and looking forward to kind of taking a closer look at it. Just a comment and then maybe a couple questions for just clarification and understanding of how what you're thinking. So first on CIC, appreciate your thoughts on that. I just want to make a couple comments on that because we did hear about that a lot. I think from my perspective, the way that CICs were proposed to be used in this particular rule were only done in a way that was going to kind of add more notice and involvement and protections. Expanding requirements for community outreach plans and for operations in those CICs. So I think it's interesting kind of how it has played out in the conversation of this hearing, given that. And I want to note, I think it has come out through this hearing clearly that, agencies such as ECMC and others clearly are authorized to, focus in on subsets of the definition of DICs, if done so, through a rulemaking hearing and whatnot. So that authority is there, and then it just becomes a policy question of when should agencies do that, right? Like when is it appropriate to do so? So I want to be clear that I do think that, that should still be a consideration at times and where appropriate. That I don't, that I agree in this case, given the feedback that we have gotten. I think it's right to remove it from this particular rule, but I don't want that to be a signal that, we think that should never be something that we would consider in the future, because it is, potentially an appropriate pathway and is specifically authorized by statute and was specifically recommended by the task force for various cases. So I wanted to just make that comment. But I do agree with taking it out here. And then a couple of questions just for clarification on the ESPs, and maybe this will become more clear when we see it all together. There were a number of comments by parties that we're just going to say like the things that were in like little I to little I4 should be like where practicable. And so I'm wondering how that shows up or gets addressed, or if it does get addressed in this. And then similarly, there was a lot of conversation about whether or not to add a requirement that would add a requirement for the use of electric drill rigs in the non-attainment area in the ozone season where practicable. So wondering if that has factored into this at all, or how that factors in.
So and I'll share the language and we can have a further discussion with it, but just in general, the 1 through 4 is now mandatory in DI. And the electricity as well as produced water both contain the practicability provision. So I've cut them and put them in kind of their own little notion so that they're on their own and they're with that practicability finding.
Okay.
Commissioner Cross?
Thank you, Mr. Chair, and I appreciate you taking a stab at some of the ESP stuff as well. And I'll say I think most of it was consistent with what I was thinking, especially in some of that organization of breaking it out. I did want to make just a couple comments about the ESPs, kind of consistent with what I was looking at. First, I know there was a lot of discussion back and forth about the legislation from some of the parties. I do think that it's appropriate to look at the legislation with respect to what it talked about with the enhanced systems and practices. Senate Bill 24-229 specifically mandated that we, in consultation with CDPHE, require enhanced systems and practices to avoid, minimize, and mitigate emissions of ozone precursors from operations at newly permitted oil and gas locations in the non-attainment area. Essentially, it says the 8-hour ozone control area in Northern Weld County, as those terms are defined by AQCC. And so I think one of the things that I'll start off saying is I appreciate the consultative efforts that we had with CDPHE in this. First, the efforts of trying to identify those, what were best management practices, and we're now putting forward as ESPs that are going to have kind of the biggest bang for your buck with respect to the ozone precursors. So I think that's very helpful. And I do think along with some of the practicability aspect of it as well, I also appreciate Ms. Sorensen's insight as to what may or may not be something that should be considered practicable versus mandatory. As she noted, there are certain things that are going to be difficult at times to do, and in certain circumstances may actually have more of an impact than not doing them. And I think that I'm happy with staff's draft of, and I am not 100% sure what the new provision would be under your red lines, but there's the provision that specifically talks about if an ESP is not being put forward, explain the reasons why, explain that the infrastructure is not available, explain that that it might have more harm than it might have good. And what comes to mind immediately is maybe a pipeline that's going through people's backyards if it's not really going to have a long-term impact. And so I appreciate the thoughts on the practicability aspect of that. One that I'd be curious about more conversation with is obviously the sandbox one. I know that was identified as not necessarily the biggest ozone precursor, but more of an operational aspect of things being done. So I think that's worth some discussion as well. But wanted to start off, I think that the approach that we've taken on this is consistent with what the legislature has asked us to do in that consultative process. And again, putting forward what's going to be the most impactful in reducing those ozone precursors in our operations. The second thing I just want to touch on is something that I think has come up before, and I know it was talked about by several parties, and that's the as practicable term itself. I personally think the term as practicable is workable and enforceable, particularly given that this provides the commission and our inspectors and our staff discretion as to how to assess practicability. Ultimately, should an operator not adhere to one of these ESPs or BMPs that require adherence as practicable, again, I think the burden falls on that operator to demonstrate the potential enforcement proceeding. In a potential enforcement proceeding, why they diverged from the ESP, why they didn't employ that ESP. You know, whether it was an upset condition, it was a safety reason, whatever the case may be. And I think that's because of that, and I know it was brought up that it's used in other regulatory situations as well, AQCC and others, and I do think it is something that is workable and is enforceable. That said, I looked to the language and what staff had put forward as the new 316C4B. Again, I'm not 100% sure on your red line where it would be now, but it talks about the requirements as to why they elected not to do it. And I think that maybe even if that's not used throughout, which I think it could be, but I think that it's also potentially good to include that in the statement of basis and purpose as, listen, when we talked about it as practicable, this is what we have in the rules under that provision is a good demonstration of what we're looking at. It's not just, yeah, it wasn't feasible, sorry, we couldn't do it. It's putting forward, we don't have the infrastructure. We talked to United Power, we couldn't get that in place. We looked at doing a pipeline, but you know, we were going to have to get 1,500 different rights of way because we're close enough to people, and that was going to be tearing up a lot of yards, and this was really only going to be used for the first 6 months if it's produced water, something to that nature. Or you know, the feasibility of building a pipeline to get to the nearest injection point is 60 miles away, and so it would be far more impactful over that 60 miles than it would be to get to a closer drop-off area, something to that nature. So I think the other thing I wanted to make sure that I hit on was just providing some guidance around that aspect of it as well, that, you know, that I think staff's efforts on that are very thoughtful. And also note that it's, you know, illustrative. I don't think that it's only showing these and you kind of stop there. I think that the list does not need to be exhaustive in what we're talking about as to reasons for it. And so I just wanted to make sure that that was addressed as well, as the term itself was brought up several different times.
Thank you, Commissioner Cross. So I will inform or have the hearing officer enter a short order requesting any feedback on these notions by close of business next Wednesday. That's 7 days out, and try to get the feedback in a one-page format so that we can hear from folks and have some understanding of that. The documents have been transferred over to hearings manager Thomas, and he's in the process of getting them out to all of our stakeholders as well as our commissioners. And unless there are further questions, I think we will let that percolate a bit and we can move on to next steps. Commissioner Messner?
Thanks for that. I don't have any questions about that process. I just want a question for Commissioner Cross. Just to make sure I'm clear, your musings on enhanced systems and practices, correct? And so your opinion is that it should be as included in the August draft with no changes. Is that my understanding?
No, I had changes that were similar to what Chair Robbins was talking about, specifically looking at, you know, I think as we did hear, especially a lot of the operators talk about, you know, yeah, I think a lot of these are workable. Some of them are harder, and the ones that kind of kept coming up, especially was the electrification aspect of things, and the produced water aspect of things. And so I think separating out those to be as practicable as opposed to, because in Chair Robbins' red line, as I was reading through it, those two were pulled out and put into a separate as practicable rather than all 6 being 100% mandatory. I think that makes sense to have it in that way. I will say I personally don't like the idea of the prescriptive mandatory requirements like that, period, outside of it being something like, do not use this chemical because it will it will kill you. So, something that's much more strict in that. But given the direction that we've been mandated to kind of adhere to and what we're trying to accomplish, I think that at least the 4 that were listed as mandatory in that what was 316C4A, I think is appropriate, and then the others being as practicable.
Okay, so this is where I'm getting confused, and I think it's because I'm looking at a red line that has so many cross, lines through it. So I'm looking at the section that says additional enhanced systems and practices, right? Which I think is 4A, but now there's a line through 4, so that may not be 4A. And so I think this is where I'm getting confused, but that has the words as practicable in it. And so,
Sure. And you're looking at,
again, I'm confused with the existing drafts. Yes.
yeah. So you're looking at the August C4A, or which one are you looking at?
Yeah, I'm looking at the August draft compared to the 614 notice CIESP draft. I'm trying to go through, and I've got, C, which is enhanced systems and practices for operations within the ozone non-attainment area. I go down, and then there's there's a section that would be year-round. There's a section that would be during the non-attainment season, and then there's a section that says additional enhanced systems and practices. And so what section are you talking about, I guess, within those sections that you would want to see as practicable utilized where it's not utilized now?
Yeah, so and I apologize, I'm not looking at the comparison, I'm just looking at the red line, just for the 8/2/24 revised draft. But if you go to C4A, it's the additional enhanced systems and practices. So what and I thought this was well done and what Chair Robbins was talking about. My first concern was that A kind of has 2 different provisions within it. One's for within DIC, one's without. So the first thing I was going to bring up is separating those out. So they're talked about differently, because where it's not in a DIC, it's already talking about where practicable, but it's kind of confusing to have both in the same area there. And so I appreciate bringing that out as so not in a DIC, all of those would be as practicable. Within a DIC, I think that as written in the 8.2, those 6 would be mandatory. Under what Chair Robbins just talked about was where I was going to go as well, and that's pulling out the electrical, which a lot of people talked about that being the hardest to do, and the produced water and permanent storage tanks being as practical as that's the other hard one to do. So those 2 would still be as practicable even in a DIC, but the other 4 would be the mandatory.
That's right.
The storage tanks, the centrifugal compressors, the pipeline takeaway, and the lay flat hose to transport water.
Okay, I guess, so this is where I think I'm getting confused is I guess I thought in Chair Robbins' proposal, he was talking about the electrification, grid-powered drill rigs, not just grid-powered production equipment as being as practicable. And so I may need to see red lines on all of this for me to fully understand it, because in here it just is in the section you're talking about, Commissioner Cross, is talking about, the way I read it, permanent electrical production equipment.
Yeah.
Not drill rigs.
Yeah, the drill rigs is not talked about in this draft, in this section. There's the previous section references the drilling requirements under the AQCC regulations that they enforce now, which is the primary focus being on the electric drill rigs, and then something equivalent, the tier 4 engines, etc.
Okay, I guess I would say then holistically, because I was a little confused there. if we're gonna use the term as practicable, I would like to include electric drill rigs in there as practicable. I understand that there are situations, just like with production equipment, that it may not be practicable, it may cause more problems than good. I mean, there are ways that I get that. But I think if we're gonna include grid power production equipment in this contemplation, I would also like to see grid powered drilling equipment as in an as practicable application.
Commissioner Oath?
I would just chime in and say I would like to see it kind of laid out also, but that is what I have been wanting to have a conversation about too in the same place. But again, want to see kind of the full picture of what it looks like. But right now would be supportive of a requirement for electric drill rigs where practicable.
All right, well, that stuff is coming your way. It's getting out to all the stakeholders, and we will continue a discussion, perhaps tomorrow after folks have had a chance to noodle over it this evening, after we're done with our hearing. AAG Davenport, do you want to visualize yourself? I've been concentrating on other things. Where do we go now?
Well, I think excuse me, I think the commission has two options of where to go now. Option one is to the table that Ms. Trask and others have been preparing. Option two is to go to my document reflecting and review what I have determined to be consensus amongst the commissioners. Maybe that would be a little less brain power required to review something you've already discussed, so perhaps it's best to move to the table at this point.
I'm fine with that. I might want to take a 10 or 15-minute break so that I've not looked at the table. I know it's in my inbox. Does that sound fair to give ourselves a chance to get acquainted with the table and then come back and have a discussion about it?
Yeah.
Yeah, all right. It's 1:42. Let's return at 2 o'clock and give us a time to really dive into the table. Introduce the table.
Thank you, Chair Robbins. I think we're trying to get the table visible here. So I might just start by saying that in developing this matrix, I took the revised red line from Green Latinos and Commissioner Messner's comments about how he incorporated some of his ideas into the Green Latinos version and the Oxy version as well. And so I've tried to sort of create an amalgamation of those three sources. I've done that in a separate table, which I'm not prepared to show because it's a bit of a mess. But then I took that information and tried to create a simplified summary that is what has been shared here and what is visible on the screen. So I've tried to break down 3 different topics. So we've got disclosures, which in current rules are called notices, but I was hearing some language from commissioners to potentially call those disclosures instead of notices. And so disclosures are basically information that is pushed out to the community. And then there's notices, and in my mind, those differ from disclosures in that a notice provides an invitation for the community to participate in something. And then there's information requirements for the OGDPs. And so I've broken this table down into those 3 subsets: disclosures and how those get sent out, notices and how those get sent out, and information requirements for operators to provide in their OGDP applications. The columns then, the second column where it says non-DIC RBUs. First, let me clarify that using the acronym RBU is going to include residential building units and high occupancy building units and schools and childcare centers, school facilities and childcare centers. I've just abbreviated it here by using RBUs. Non-DIC RBUs, those then would be RBUs that are not in a disproportionately impacted community. And then the next column over DIC RBUs, those are RBUs that are within a disproportionately impacted community. The next column over is all RBUs. So that's just looking at all the RBUs regardless of their disproportionately impacted community status. And then the last column is notes. So starting with disclosures, we've got Rule 301H, which is a new rule proposed here, the pre-application notice, or an expansion rather, a pre-application notice. I'm proposing generally, as you'll see in this table, that those notices are sent out to any residential building units that are not in a disproportionately impacted community out to a radius of 1/2 mile. And where there are residential building units within 1 mile of the working pad surface, those are disproportionately impacted community RBUs that get that notice. So a 1/2 mile notice or disclosure sent to non-DIC RBUs and sent to 1 mile, sent out 1 mile from the working pad surface for RBUs that are in a disproportionately impacted community. The rule language currently is that this is mailed by the operator. I don't know that at this time, staff is not proposing any change to that. Rule 303E, the notice of completeness determination, that takes a similar radius of 1/2 mile for non-DIC RBUs and 1 mile to DIC RBUs. Again, mailed out by the operator. The third notice is 306C, notice of director's recommendation. So this is sort of at the tail end of the permitting process when the technical review is finished and the director issues her recommendation to the commission. Current Rule 306C it describes that this notification comes from the director, not from the operator, and this notification is electronic. So for now, this limits staff to only being able to notice electronically. So what we're proposing here is a bit of a rewrite of Rule 306C to insert a new Rule 306D that basically complements 306C, where under 306C, the director will notice electronically the list that currently exists. So we'll notice the operator, we'll notice CPW and CDPHE, the local governments, anyone else who provided a written comment. This is an electronic notice because we have it built into the eForm system as an automatic email. So it doesn't take any additional effort for staff. But in able to notice anybody beyond that, we need email addresses, and staff won't have access to those email addresses. And so I'm proposing inserting new Rule 306D that would read something like this. The operator will provide notice of the director's recommendation within 7 days to all residential building units within a disproportionately impacted community that are within 1 mile of the working pad surface, and all RBUs that are not within a DIC that are within 1/2 mile of the working pad surface. So it takes the same 1/2 mile and 1 mile radius from the earlier disclosures and just adds that into the notice of director's recommendation. There's some efficiencies found here in that with the pre-app notice and then the notice of completeness determination, if the operator identifies the RBUs within a 1/2 mile and the RBUs in a DI and any DI community RBUs out to 1 mile, they have that list of addresses because they've already noticed 301H and 303E. So it would be a similar notice here for the notice of director's recommendation. I also think that's compatible because if those residents are being noticed of the pre-app note, they're receiving the pre-app notice and they're receiving the notice of completeness determination, it makes sense to me for them also to receive the notice of director's recommendations, or sort of the beginning, the middle, and the end, receiving 3 different notices that are occurring throughout the permitting process. Along with that, though, instead of having the operator provided in writing, which is what they would be doing already, we could include rule language that provides mechanisms for the operator to provide these disclosures or notices via other means besides a mailer or a postcard. This could be on social media, on the operator's website, through local newspapers, whatever types of communications are most effective, particularly for residents in disproportionately impacted communities. I would encourage that the commission directs staff to come up with some language around how else can these notices be sent out or provided to residents within those radii, but also to the general public where applicable. So then the second section below, notice, these are the invitations to the various meetings and consultations. I want to clarify that the approach I took here is that where there is a consultation, I'm treating the consultation as a meeting of subject matter experts. So the director, ECMC staff, the operator, the local government, CPW, CDPHE, other entities that would provide insight on the process of the permit and or the technical components of the permit. So for consultations, we're indicating that the residents within 2,000 feet, regardless of DI status, the residents within 2,000 feet would be invited to that consultation. They're the people who live there. They're the people who should have the most access to participating in the early stages of the permitting process here. And then where I've indicated a meeting, so 301G pre-app community meeting or 309C post-completeness community meeting, those are less subject matter experts and more would be open to the general public. So that's a distinction I've taken the liberty to make here, and I'm open to direction on meeting versus consultation. For the 301F pre-app consultation, I didn't indicate a notice of any sort because 301F is the local government, the relevant local government's pre-application consultation, and I'm uncomfortable assigning, sort of inserting ECMC's process into the local government's process. So I've left those as NA. If the local government asked ECMC to send out those notices, I would possibly counter and say that that would be something that maybe the operator could send out. So for the 301G, this is ECMC's proposed pre-application consultation. Again, including those subject matter experts and any residents, regardless of disproportionately impacted status, any resident within 2,000 feet, this would be mailed by the operator and would not include the general public. The 301G pre-application community meeting is a new topic that has come up over the course of this hearing so far. And I would propose that as a 1 mile notice. Again, regardless of disproportionately impacted community status, I think this would be provided by operators open to the general public. And again, would ask the commission for direction on how this notice is provided by the operator, if it's in writing, if it's just via a postcard, or if it should include other means of getting the notice out, such as social media, newspapers, the operator's website, that sort of thing. 309C then is the post-completeness consultation and community meeting, again, broken down into the consultation being the subject matter experts and the residents within 2,000 feet. And then the community meeting being open to the general public out to a 1 mile radius from the working pad surface. The last section towards the bottom are the information requirements for OGDPs. there are two plans, or one attachment and one plan. So 304 B7J is a disproportionately impacted community map. Staff is proposing that this map is only required if the location is within 1 mile of any RBUs that are in a DI community. Another option that just occurred to me is that this would be required if the location is in a disproportionately impacted community, regardless of proximity to any RBUs. But that this wouldn't be required if there are no disproportionately impacted RBUs within a mile. I'm probably not saying this very clearly. Hopefully the matrix is more clear than how I'm presenting this today. And then similarly, 304C19 is the community outreach plan. This plan would be required as part of the OGDP application if there are residential building units within a half mile of the working pad surface. If those residential building units are in a disproportionately impacted community, then that radius expands out to 1 mile. So essentially would be the plan would be included if there are any RBUs within a half mile. And if there are any disproportionately impacted RBUs within 1 mile. So this plan will be required then if there are any houses within a half mile, but then expands to capture any disproportionately impacted RBUs out to 1 mile. And then the last line there, director consultation with CDPHE. This is existing rule 309F. We're proposing only a minimal change that the director seeks consultation with CDPHE for any locations that are proposed within 2,000 feet of any RBU. Where there are disproportionately impacted RBUs, that radius expands out to half mile. This is a little bit different than higher up in this matrix where it's a half mile for non-DICs and 1 mile for DICs, only because I want to acknowledge that I don't think it's the commission's intention to mandate that CDPHE staff participates. I think we can ask them to participate, and where they can, where they're able and interested in participating, CDPHE staff would do so. But I just wanted to provide a little bit of a buffer there for CDPHE staff. So apologies for the mess that I just walked through. It's probably a lot easier to understand this just by looking at the matrix in front of you, but I'm happy to try to answer any questions.
Ms. Trask, is kind of a fundamental question. So we don't do notice to DIC RBUs because that's what we're debating in this, like current practice. So current practice is notices to RBUs. And is current practice what's illustrated in the first bullet, the half mile, etc.?
No, current practice is not shown in this matrix.
What is current practice?
That's a good question. I have it in my other notes here. Current practice is basically the notice goes out to a radius of 2,000 feet, regardless of who is within that 2,000 foot. And so I think some of the complexity arises when I think that initially my brain is slowing down. It's in the afternoon slump. I think the initial intent was that if the location is outside a DI community, then the notice goes out to 2,000 feet. If the location is inside a DI community, then the notice goes out to a greater radius, whatever that might be, a half mile or 4,000 feet or a mile. In reality, it's not that simple, and that's where the complexity of this starts coming into place. There could be a location that is outside a DI community, so the current rule would trigger a 2,000 foot notice. The problem is that there are, regardless of where, if the location is outside the disproportionately impacted community, it's only going to notice to 2,000 feet. It could be missing people that are living in the DI community. And so it might have 5 homes within 2,000 feet that are not in the disproportionately impacted community. It might have 30 homes at 2,010 feet that are in a disproportionately impacted community. So I'm trying to shift the focus away from, is the location in or out of a DI community, and instead turn the focus towards wherever that location is. Let's look out to a given radius and include RBUs that are in a DIC, even if the location is not in a DIC.
Okay, I think I'm not understanding everything as well. I know it's afternoon slump here. The current practice is the notices under what's called the disclosure section,
Mhm.
they go to 2,000 feet. Is that fair?
I believe so. I have to check in the rule because I don't remember off the top of my head.
I'm just trying to get an understanding of current state versus what we're debating in terms of what future state may be for both
Yes.
non-DIC and DIC.
Yes, 301H currently as drafted in the August draft, the notice goes to 2,000 feet. And there is no distinguishing of whether that is a DI community or not. It's just a 2,000 foot notice to everyone.
And is
within.
there current state is 303E and 306C? Do those both go to 2,000 feet?
Yes. Yes.
Okay. Another current state understanding. Back in a former life, when I was a local government lawyer, I represented a lot of planning departments. And I know that planning departments require notice to go out for potential new uses, entitlements. I'm familiar with not providing sort of like the planning departments I represent just generally provided one notice at the outset when the application was filed. This has us doing 3 notices, and it has us doing 3 notices to a half mile and then to a mile if we were to take what's on the face here. Do you have any thoughts about whether 3 notices, especially if we're going this much further out, make sense, provide value add? I mean, like, it almost to me like it could be like, especially if we're contemplating going this far out, you know, folks may not, I mean, if they get the notice of the pre-app and then they like, I don't know, send their email, then they can get more notices because that shows they're intrigued or that they want to be involved. I don't know. Have you given any thought to anything along those lines?
I have not. And apologies, I should have. I have not thought about that. I do think it's a good idea. I think where notices can be targeted to those people who are most interested in receiving them, I think that we should strive for that. And I think as much as possible where notices can be delivered electronically via email, saves a lot of time and a lot of money over sending out postcards.
Well, and again, I, at least as one commissioner, am interested in exploring that topic, especially since we're going from current state of 2,000 feet to potentially a mile radius around a location. So I'll stop the questioning there. Thanks for informing us of current state, et cetera. And I'll look to my fellow commissioners, and John Messner has already raised his hand. Commissioner Messner, you're up.
Thanks. I think you're right. I think in the local government processes, there are not this many. And so I hear that, and I think that that's accurate, particularly in the disclosure piece. And so one suggestion may be is that a pre-application notice goes through a level of formality that you would typically see in the local government level that isn't just a postcard going out, but is certified mail or something that would have confirmation of receipt. So you go through a little more robust process at the pre-app piece. Make sure that that notification includes clear indication of how they can get additional information as the process continues. And so they could go onto the website, they could provide their email, they could then continue to get information electronically for other stages in there. And then that would meet the requirements of any notice for completeness determination or for director's recommendation. Because the director's recommendation piece has its challenges as well, because if we're asking the director's recommendation to get mailed out as per this matrix and the suggested language, sometimes that director's recommendation doesn't come out until, you know, less than a week before the hearing. And so they may not even get it until a decision has been made. And so I think the electronic piece makes some sense. And so I hear what you're saying. And so I think having that first piece be a robust notice and then have the other ones be, you know, there would have to be action taken by the folks that got noticed with the first pre-app notice for them to get notified of subsequent information associated with the disclosures. At least I have to think a little more about the other ones, but from a disclosure standpoint, I would agree with you.
Commissioner Cross?
Thank you, Mr. Chair, and thank you to both you, Chair Robbins and Commissioner Messner for the kind of relation back. I know especially yesterday, the information about what happens at the local government level was definitely helpful for me. So it's helpful to understand that perspective as well. Without going into distance aspects, I think that's helpful to know as well that the pre-app is where a lot more of the formal happens. Because that was going to be one of my questions as to where is with 3 kind of disclosure timelines being a lot, where is the best place to get an idea of where the involvement should come in. And so hearing that the pre-app notice is kind of the detailed one, that's helpful to know, especially as we go to the invitation to take actions. I think that based on that pre-app, then you start to get the invitations for the public participation aspect of what this disclosure, what this notice is going for, given that that was one of the things that the environmental justice groups talked a lot about, providing the opportunity for time and for opportunities to give their opinions, give their concerns, give their questions, et cetera. And so it's helpful to know that. Without going into distance aspects, I think my one concern, and it might be helpful to have AAG Davenport here for this discussion, is the completeness determination. And the reason I ask about the completeness determination, and I'll give my maybe suggestion in a minute as to that, 303E currently is sent to who can be parties at our hearings. It's not listed as the affected parties, but those that can be the parties, the affected party status, whether it's within 2,000 feet, the other agencies, the relevant local government, et cetera. And 303 is in reference to 504, which talks about the notice in the same way, which is also referenced in 507, which specifically talks about notice within a legal sense as that affected party status. So, and that's part of why I wanted to understand where the detail was, is I just want to make sure that we're not changing affected party status. We're not, the notice aspect, the disclosure aspect isn't changing other parts of our rules as to who's the affected party status. And so I wanted to make sure that I wasn't incorrect in the things I was saying, and that's why I asked AAG Davenport to come up, and so I think my proposal with that, instead of potentially impacting the 303E, is that one necessary under what Commissioner Messner and Chair Robbins were saying as part of that, maybe you could ask to get more at that pre-application notice and potentially do a different section that talks about disclosures for those interested as identified after the pre-application notice. And I guess to start, AAG Davenport, does that make sense in kind of how I raise that issue?
Thanks. That made sense to me, Commissioner Cross. As I understood your question, was it kind of by sending notice, are we conferring or lending support to an argument from someone that they have standing to participate as a party in our process? Is that
at least with respect to the 303E, because at this point in time, those that receive the completeness determination are the affected parties or the presumptively affected parties.
It's accurate to say that under current 303E, there's significant overlap between the group of folks and governmental agencies, et cetera, who are entitled to receive notice under 303E and the quote unquote automatic standing categories of folks in Rule 507. There's no intent there, in my view, to only send notice to those folks who have automatic standing. And in my view, again, by sending notice, ECMC would not be conferring standing or lending credence to an argument that someone has standing pursuant to Rule 507 to participate as a party. If that's a concern of the commission, and the commission wants to be clear that regardless of any overlap, the intent is not to confer standing by sending notice, then I'd recommend including a sentence within the SBP to make that intent clear.
Okay. And that's helpful. I just wanted to make sure. And again, I like the idea, I don't want to say propose, but kind of that idea of using the pre-application notice to identify the additional parties that are those that want to continue to be involved in the process, that want to get the invitations to the community meetings, those that want to get invitations to additional discussions or have reach out from the community liaison, et cetera. I think that I like that idea of making sure those that want to be involved can be and are involved. That was, I think, my initial.
Others with thoughts? Commissioner Messner, I'll get right back to me. Let me get another commissioner with initial thoughts. Commissioner Ackerman?
Thank you, Mr. Chair, and thank you for your thoughts on this as well. I also like the idea of broad original notice and then subsequent elective electronic inclusion afterwards. My one kind of deviation there, and you may have touched on this and I missed it, and I apologize if that's the case, but we do have the pre-app consultation invitation and the post-completeness consultation invitation within 2,000 feet that's not open to the public, that to me might still warrant some special invitation. And I was taking notes, so I'm not sure if you touched on that or not. But if not, my encouragement would be that those aren't somehow down the road elective, but we remain proactively reaching out to those parties.
Commissioner Messner?
Thanks. I agree with Commissioner Ackerman. So maybe let me walk through this list from my perspective and see if it concurs with where Commissioner Ackerman's at. And I think Commissioner Cross, and well, we'll go from there. So the pre-app notice, so this is the first notice. Hey, there's an application coming. That goes out broadly, formally, with certification mailed. And then the next two lines, so 303E, 306C, would be elective electronically. And so folks that are interested receive the postcard from the pre-app notice, can sign up to be informed of future notices and information associated with this application, because the notice should also tell people how to engage in the process. And so those two are electronic and elective. The pre-app consultation invitation should, should be, because it's inside 2,000 feet and it's asking for additional action for those inside 2,000 feet, that actually should be proactively mailed, so that all those inside 2,000 feet. So I think mailed, emailed, the multiple opportunities for engagement, phone calls if possible, because there's a relatively finite number of people for 301G. 301G pre-app consultation, 301G pre-app community meeting invitation. That again is broad. I think that also has to be, that should be posted on a website. We should utilize social media. We should email folks. And I think there has to be a mailing associated with that one. The post-completeness consultation, again, is a finite number of people. And so you're reaching out to the same people that you did for the 301G pre-app consultation. And the post-completeness community meeting invitation should have the same notice requirements as the 301G pre-app community meeting invitation. The DIC map is a submittal requirement. 304C19 are submittal requirements. And 309F is a submittal or a process thing. So none of those are notices. Anyone that's interested in being on a list, so at least my experience is that, local governments have the ability for anyone that's interested in a particular application process to receive notice, sign up to receive electronic notice for that application as it goes through the process, so that anytime that there's a milestone in that application process, they get noticed, they get information, or at least know how to access information for those processes. And so I think this is in line with that.
Others with comments? Commissioner Oath?
Thanks. And this is sounding really good. I guess I have a clarification question, and I think I've gotten a little bit confused around the pre-application consultation meeting invitation. Commissioner Messner, maybe I misunderstood when you were sort of leading your thoughts on the pre-application process the other day. And knowing that we got a fair amount of testimony about the technical nature of that meeting being between, the agencies and the local government and the operator, I thought that where that was headed was that it was not the right place for involving residents, and that the community meeting is the right place for involvement at this stage. But am I confused?
No, you're not. That's actually where I was. I'm reacting to what the matrix is saying.
Okay.
It wasn't clear to me that all the commissioners were on board with that, but I would continue to agree that the pre-app meeting is just that. It's an informal, non-public meeting to engage operators and have high-level discussions about submittal requirements and aspects associated with the application and the application process. And that the community meeting is where operators, applicants would have the opportunity to solicit feedback from community members on an application before it's submitted. So I still agree with that. I'm just reacting that if
Okay.
this is the way we're going to go with it into 2,000 feet, then it should be noticed. Otherwise, I don't think there's a notice requirement necessary there because you're having direct communication with the folks that would be invited to a pre-app meeting.
Okay, well, apologies for not, yeah, this is that's super helpful. I am in agreement with you that the right place to involve residents is at this community meeting. I think we got testimony kind of from many parties on all sides that was the right way to address that issue. So I would agree with you. And so the extent that we're like coalescing around the matrix, I think I would want to strike that part.
Others with thoughts? Commissioner Ackerman?
I didn't quite follow that last part, Commissioner Oath. I'm sorry. What is it that you would like to strike? I didn't quite follow. I apologize.
That's okay. I think it's the 301G pre-application consultation invitation. Is that, as I understand it, and I was in agreement with Commissioner Messner that pre-application consultation, which I would agree with also renaming that to pre-application meeting, is intended to be a very technical meeting between the agencies and is not the most meaningful way for residents to get information or to provide feedback, and that the pre-application community meeting is a much better place for both of those aspects to occur.
Thank you. I appreciate the clarification. And I agree with all of that philosophically. Just to be clear, my understanding is that we would then have direct outreach, as Commissioner Messner had talked about, to those within 2,000 feet for the pre-app consultation invitation or rename pre-app meeting, right? Is that what you're saying? That would, you said stricken, but my understanding is that there wouldn't be, public notice of that, but there would be direct reach outs to those people, right? Am I tracking?
Who are you asking?
Commissioner Oath, I'm sorry.
Well, actually, I would love Commissioner Messner to give his take of what he was envisioning for that part.
I think you're right. So I think this is getting a little skewed. So if I remember what I said, which is sometimes not possible, but if I remember it, I can go back and look at my notes. But that the pre-app meeting is the technical meeting amongst agency staff, and that would occur, that does not include the public. But the pre-app community meeting inside of a disproportionately impacted community would extend out, invitations would extend out to a mile. And outside of a community, or outside of a disproportionately impacted community, that would extend out to a half mile. And so that would be an active invitation for those within a half mile outside of a DIC and within a mile inside of a DIC to engage in a pre-app community meeting that would inform the operator on any feedback that the community may have that they should consider in their application before it's applied for. And so that's what I would change in there. And then for me, again, I don't know if there's benefit to a post-completion meeting, but if staff feels like there's benefit there to have that post-completion meeting and an invitation or a second pre-app meeting or a second meeting post-completeness, then I think they can do that as part of their technical review process and invite the folks that they think need to be in that meeting in order to have that conversation. So I don't think that there's a notice requirement for that necessarily. And, in the situations where there's a post-completeness community meeting required by our rules that the applicant hosts, then again, I think that should be half mile outside of a disproportionately impacted community and a mile inside of a disproportionately impacted community, unless the operator wants to invite a broader range to engage in that. And so that, if I remember right, that's kind of where I was going with that. And so does that make sense what I'm saying?
Yeah, thanks for sticking with me on that, both of you. I really appreciate it. And understand that we don't have a current pre-app consultation invitation to those parties, and rather we invite them at a later stage, and just wanted to make sure we were following that same process. I'm supportive of that as well.
Commissioner Cross? Sorry.
Thank you, Mr. Chair. No, you're fine. And I'd say I also agree with you on that, Commissioner Messner. I think the pre-app consultation is appropriate for kind of the, whether it's the relevant local government, CDPHE, CPW, ECMC staff, et cetera, to kind of have the discourse about the issues, trying to identify ALAs that should be addressed, et cetera, to make sure that those are talked about. And then the pre-app community meeting being appropriate to get that insight before something is actually filed to get that community input. And so I think I'm absolutely in agreement with that. And with respect to the post-completeness community meeting invitation, I'm also on board with you there. I'm not sure if it makes sense to require the post-completeness community meeting, or if that would be something that can be talked about as part of the community outreach plan itself, the 304C19. Whether as that's something that, maybe in consultation with the community liaison, you determine where meetings might be, when they might be, that kind of information. And so I think that I don't know if those two sort of overlap, but I'm not against the post-completeness community meeting. I agree with you. I'm not sure if it's duplicative or if it's necessary, given that there's going to be additional outreach we do. And I just highlight here as well, I know we've also had discussion of the kind of other side of the notice, and that's the opportunity to provide the public comment and the timelines for that, as opposed to just the timelines or the distances for who gets the notice. And so I don't know if this is an appropriate time to talk about that as well. The expansion to the 60 days within the DICs. I was generally supportive of that additional time that was provided as well and talked about by the parties. So I'll throw that out there. And then the one other thing that I think is worth bringing up, and we talked about it before, the half mile, the mile. I know previously I said the half mile, I think, works to get beyond the current 2,000 foot radius that we're talking about. Also recognizing that I know Green Latinos had mentioned in the rebuttal and kind of after they were brought back up that they'd be willing to go to 4,000 feet on that notice, and thought that was appropriate with the CICs not being included. I'd also throw that out there as another possibility. And I know Commissioner Messner, you wanted to tie it to the impact area, but given some of that EJ group discussion of the 4,000 feet, I thought I'd throw that out there as well.
Commissioner Messner?
Thanks, and thanks, Commissioner Cross. I appreciate you bringing up the timing for public comment. I do think that ties in here, and agree. Just so I want to clarify what I thought I said. I do think that there's expectations inside of community outreach plans that contemplate a post-completion meeting without titling it that. It's part of their community outreach plan. And so I think that having that requirement or expectation that there's a half mile for notice for those community outreach plans, those post-completeness meetings from a notice standpoint and a mile inside of disproportionately impacted communities, I think it should be captured that that's an important notice piece for those community outreach plans. That would happen post-completeness wherever it is applicable in the rules. And so do want to capture that, but I'm a little unsure. I think that's what it's saying here is the 309C19. No, that's 304C19. So anyway, I want to just capture that piece. And then I mean, I don't feel like I have to say anything more about where I'm standing on the mile versus the half mile piece. And so I think both of us, you know, have our positions on that. And so I'm not gonna, I don't think I have to say anything else there. So thanks.
Commissioner Trask.
Not sure who that is, but thank you for letting me jump in here. I wanted to confirm the current state. And again, apologies that I didn't think to put this in this matrix. So current state, we do not have a 301H pre-application notice, and we have not been including non-technical participants in that meeting. It's just been a technical meeting. 303E is a current rule with a notice of out to 2,000 feet. 306C is a current notice of out to 2,000 feet. I think the reason for the 303E notice is because that is when the public comment period opens. And so it's the notice to say, it passed completeness. The application is now uploaded to the website. It's available to anyone who wants to review it, and public comment period is open. So that's sort of the meaning behind that 303E notice. The 306C notice, and I'm not proposing to go down this rabbit hole at this time, unless the commission wants to, but that's the notice of director's recommendation. And that's to say, here's the director's recommendation, and sort of provide additional information about how to participate in the hearing. So how to sign up to give oral public comment at the hearing, that sort of thing. Back to current state, 309C post-completeness consultation invitation. That's sort of that subject matter expert, that's our partner agencies. That currently also gets noticed out to 2,000 feet to residential building units. And that is in 309C under building unit owners and tenants. An operator will be available to meet for a formal consultation process with residents of building units within 2,000 feet of the working pad surface. So those are not new to this matrix. Those are in our current applicable rules. What's proposed in the matrix here is just the expansion of the radius for those, and then the addition of the pre-application pieces, both notice and invitations. And then the post-completeness community meeting is another new piece, but the other ones are already in our current rules listed for a 2,000-foot radius.
Thanks again for clarifying current state. It helps me get my hand around where we should, or at least I, as one commissioner, believe we should end up in future state. And so with that, if 301H, the pre-app, doesn't even go out, but the 303E notice of completeness goes out to 2,000 feet currently, and if we're considering moving that to a half mile or even a mile, and the notice of completeness is really a notice of public comment is now open. I think that's what I heard you say, Ms. Trask. Is that right?
Yes, that's correct.
Okay. Then I am comfortable with, first off, on the distances, I think moving from 2,000 feet to a half mile and then to 4,000 feet is fine. I mean, that's expansively different than where we are now. And then I also am comfortable with both of those first two notices being just postcard notice, especially if it's going to happen twice. And then the second one should have the information on how to opt in to get additional notices down the road. But that way they're getting notice of pre-app and then notice of completeness, which gives them notice that they can then start to participate. And that's two notices that are going out. It's much more expansive than what current state is. So I think that's where I could end. I'm not totally wedded to any of this. I do like the concept that after a notice or two notices, there's some form of opt-in provision to, so that we can, number one, do it electronically, and two, stop the notices for people who don't really care. So those are just some musings for the cause. Commissioner Messner?
So I'll one up you there. As I'm thinking about this, and someone tell me if I might be missing something here, but there may not be a need for a 301H pre-app notice at all. Because if we're going to have a notice of completeness, and we're going to have a notice for the pre-app community meeting, which is really the first time the community can engage, then that pre-app community meeting notice can really act as the pre-app notice, and then the notice of completeness determination can also be, would further that notice on to let folks know that public comment is available. I think the pre-app community meeting invitation needs to have enough information in it that even if someone can't make the meeting, they have enough information to know how to continue to engage in the process. So essentially combining the 301H pre-app notice with the 301G pre-app community meeting invitation notice and eliminating that 301H pre-app notice, I think still accomplishes the exact same thing and still gives people the opportunity to engage at the same level.
Thanks. Commissioner Cross, I think you were next.
Thank you, and I think I followed that, and I think that makes sense as well, to not have that kind of duel there, as long as they are getting the notice to make sure they can participate in that pre-app community meeting. I was going to go a slightly different way there and potentially throw a wrinkle into what was raised by Chair Robbins, and that's maybe, if we send out a postcard notice and the opt-in for additional things, I wonder if we want to make sure it's not just opt-in for email notice moving forward, in case there's email considerations with some of the individuals, if they prefer to get mail, or if they prefer a phone call or something of the sort, if there's email considerations. You're on mute, Mr. Chair.
I'm on mute. Seeing a break in deliberation, I could use a little bit of a break. We've been going at it for 2 hours. So why don't we continue our thoughts on this, take a bit of a break, come back, try to finish up on this topic, and then we'll move to AG Davenport. Let's return at, let's see, 3:06. All right, welcome back. AG Davenport, thanks for visualizing.
Yes, Chair.
Do we want to get back to the notice pieces first? What are folks' pleasure? Okay, Commissioner Ackerman, you nodded first.
Thanks. Yeah, I would prefer that, because I do feel like we're coalescing around consensus here. And I just wanted to make my final points on this one, and that's that I concur that it's probably unlikely that we need a 301H pre-app notice, as it's quickly followed up by a notice of completeness determination that can act as that initial notice, provide an opportunity for people to sign up electronically. I like the distances on non-DICs in the chart. I'm okay with 4,000 feet on DICs. I just want to ensure two things, and then I'm okay with largely electronic notice from that point forward, but just wanted to ensure that I think the most important notice that goes out is probably the broad community pre-app meeting. And so I think it's important that we have significant and broad outreach there through mailing, posting, contacting everybody that signed up through the notice of completeness determination. And then I just want to make sure that we're not moving away from continued and specific contact and communication with any residences within 2,000 feet, whether it's DIC or non-DIC.
Commissioner Messner, then Commissioner Cross.
Just to be clear on the timeline, Commissioner Ackerman, so I appreciate it, but the way I see the timeline working is you have the first notice that's going to go out is the pre-application meeting, because that'll be the first thing that happens. And then there's going to be a completeness notice, and then the other notices that follow. And so the first notice that will go out will be the pre-application meeting notice, because that'll happen prior to completion. And so I hear you. I think both of those should be kind of on the high end of the robustness as far as, you know, what needs to happen from a mailing standpoint, and social media and websites and emailing. And then moving forward from there, it's, at least the way I'm reading it, it would be generally you would have to opt in for additional notices continuing down from there, beyond the standard notice folks that are included in the rules, including local governments and such.
Yeah, thank you. My mistake on the timeline. I concur.
Commissioner Cross, did you raise your hand?
I didn't, but I'd say I agree with that timeline. And then just want to make sure we don't alter the notice that is provided to others as well, such as the relevant local governments, proximate local governments, agencies, etc. Just want to make sure that we're clear on that we're not changing those provisions.
Mr. Chair.
Hold on, I'm muted. Commissioner Oath.
Oh, AJG Davenport, did you have something?
I did. I don't want to interrupt the conversation. I'm wondering if the best way to capture this is to ask Ms. Trask or anyone else who has access to that table to put it back up. And then that would mean that Ms. Trask, if you have editing access to that document, would it be possible for you to be a scribe? I hope that it doesn't take a lot of writing. Maybe it's just changing numbers. Or if you would rather not, if anybody else that has access to that document could be a scribe, because my hope, though I'm happy to obviously hear alternative suggestions, is that we can edit this document to reflect the consensus. Is that a reasonable path forward?
Yes, are you able to see the spreadsheet?
I am.
Yes.
Okay, yeah,
Okay.
I'm happy to be scribe on this.
So I believe the initial consensus, if I might, is to just delete 301H pre-app notice entirely.
Why don't you just run through the list, AG Davenport, and if someone wants to weigh in, great. If not, we'll just, whatever you say is going to be the deal.
Hey, I'll do my best. I think maybe the best way to do this also is to say, we have the current state table that's highlighted in yellow. That's not going to change. That's just for reference. What will change are the next two columns, non-DIC RBUs and DIC RBUs. I think for 303E, notice of completeness determination, that is staying as a half mile, and the next column over, DIC RBUs, is now 4,000 feet, and that should essentially be repeated for anything else that's not going to be sent to only folks that express interest. Is that accurate?
So from my perspective, that's what I'm hearing the majority say. I will make my last pitch for the mile in that, you know, I think that's what we're hearing the disproportionately communities ask for. And so I think it would behoove us to listen from a notice standpoint. But I also acknowledge that Green Latinos brought forward the 4,000 feet, and I hear the majority of commissioners latching on to that.
The last thing I want to do is put words in anyone's mouth, but is it acceptable then to sort of stick with 4,000 feet for RBUs and DICs as a consensus at this point? Does any commissioner have any alternative to 4,000 feet? Other than Commissioner Messner, of course. Okay. I will move on then. Next row 306C, notice of the director's recommendation. I believe the consensus here is that is also that would be only to those folks that have expressed interest. Is that accurate?
Just go ahead and pipe up. Go ahead, Cross, and then Ackerman.
And this is the one I wanted to make sure, because I know that Ms. Trask was also saying that the notice of the director's recommendation was also what started the public comment aspect of it. No? Okay. Okay. Then I definitely did write down the wrong part on that then.
I believe that's completeness.
Okay.
So there would be no then for 306C, the distances would not matter because those would only be sent electronically to those who've expressed interest in receiving additional communications.
Thanks, and that ties in with my point, Councilor Davenport, that, and maybe Ms. Trask can help me out. I just once again, want to make sure that if there are RBUs within 2,000 feet, do we need to specifically specify that they would also proactively receive the director's recommendation? Or are we saying that if they don't sign up in the initial process, that they wouldn't be included in that list? And Ms. Trask, you can help me here, do we proactively do that currently? Or I know that the operators generally are in close communication with folks that are within 2,000 feet. And I believe that the primary way that they ultimately find out about most actions is through the operator. But I just want to make sure that we're not leaving somebody within 2,000 feet behind that doesn't sign up.
The current rule is that we send the notice of director's recommendation to those people who have provided a public comment, and that is regardless of their proximity. We get those public commenters' email addresses through the public comment portal where they submit their comment. And we send that out to the residents within 2,000 feet. If I recall, I need to double check that or have one of the AGs double check that for me.
Thank you. Then I'm okay with this as written then, Councilor. Thank you.
Okay.
So just to be clear, Commissioner Ackerman, when you say you're comfortable with the way it's written, are you suggesting that we continue current practice there, or as it's written here, which would be they would have to opt in based on either the notice that they received from a completeness determination or the notice they received as part of a pre-app meeting notice?
I think with the communications that will go out to people within 2,000 feet, I think it would be very unlikely that somebody within that radius would not be captured within the process through operator communications and through this process. So I'm okay with that. If that's the consensus, I'm okay with that. I'm certainly open to talking about including further notice to people within 2,000 feet. I believe our current practices get us there, and it's largely through operator communications. So as written is fine.
That's right. I would agree with you. I do think that people inside 2,000 feet through the other processes that we've identified here can and shall be included in this list. So
Thank you, commissioners. Ms. Trask, I lost the document. I'm not seeing the document where you were recording commission consensus.
Yeah, I apologize. I just lost it. Hold on one moment, please.
And I will try to keep the conversation going. My understanding is the notice of, oh shoot, hold on. Okay, the next one is, I believe 301F pre-app consultation invitation. My understanding of the consensus is that would not be sent out either, which is also consistent with current practice. Is that accurate? Okay, seeing nodding of heads, or sorry.
Well, there's a wrinkle there, and there's a wrinkle there because at least in the pre-app process that I had lined out, and the local government engagement piece that we had talked about, at least my understanding is that there was some consensus around the idea that that this commission was good with, utilizing the local government pre-application process if it met basic requirements of 301G. And so that does add a wrinkle to that, because if we just defer to the notice requirements of the local government in that situation, then it may not comply with the notice requirements in ours, which means that in turn we would have to utilize our 301G process for a pre-application meeting or a pre-application process.
And I think I screwed this up. This 301G is the local government, so
No, you're right.
we can't make changes, or 301F is the local government's process, so we can't change that anyway. I'm speaking about 301G. That's my fault.
Good. So I think my understanding of the consensus here is that the 301G, which is the pre-application consultation or meeting invitation, does not need notice because the public is not engaging in that meeting, but rather engaging in the pre-application community meeting. And so that one has no notice requirement.
And that's what I meant to say, and was seeing a lot of heads nodding yes. So what Ms. Trask has just entered into there is what we'll treat as consensus, unless there's an objection right now. Great. The 301G, the next one, pre-app community meeting invitation. I understand the consensus to be thus far that this is also a robust one, similar to 303E or the same as 303E. So there would be that would also be a mailing, I believe, and we would follow the half-mile, 4,000-foot distances as well. Not seeing any objections, so I'm going to move on. Next one, 309C. I'm actually not sure about this one. Does anyone, does any commissioner have,
I think my understanding is this is where you have the consultations with CDPHE, et cetera. So this would not be a public engagement.
this would be the same as 301G pre-app consultation invitation then? No notice, no public engagement?
Yes.
Okay.
If I may, current Rule 309C requires the operator be available to meet with anyone residing within 2,000 feet. That is not the CDPHE consultation with the director. 309C post-completeness consultation invitation is in the current rule, and it is where the operator offers to meet with anyone residing within 2,000 feet. So I would hesitate to lessen that. The August draft rule proposes expanding that such that if any of those residents that are within 2,000 feet are also in a disproportionately impacted community, then the operator will host a community meeting in consultation with the community liaison.
So that I understand, I mean, if it's in there and it's important, it's an integral part of the rules, then I would agree. I don't want to lessen it. And I think it's part of how you're contemplating your review process. And so I'm fine leaving it as is for a post-completeness meeting invitation and a post-completeness community meeting invitation, as applicable in the draft of the rules. If we're going to put distances on those, then they should be consistent with the 2,000 feet for the post-completeness piece and the 4,000 feet as determined by the majority for the community meeting.
Perhaps
Also, an
I-
opt-in situation for those as well.
if I may make a suggestion on the fly, I think maybe we could turn the 309C completeness invitation into just one invitation. Take the two that are itemized here and just turn this into one. Because the consultation as written is intended to be the operator meeting with individuals, so potentially having multiple meetings as individuals within 2,000 feet requested. I think we could possibly eliminate that by changing it into a community meeting whereby everyone within a certain radius and the general public is invited. The timing of this is important too, because this is when the application passes completeness and becomes publicly visible on the website. So it might be an opportune time for the operator to connect and engage with community members so that they can provide more informed public comments.
I'm in support of that.
Yeah, I think I can be good there.
Same.
Great job.
So just to follow up, is this an opt-in situation in the consensus of the commission, or is it a half mile, 4,000 foot mailed out invitation obligation?
I think I'm good with it potentially being opt-in. They're going to have received a lot of notices ahead of this.
So my understanding, at least what Ms. Chass said, is that it was a if then this, right? So if there was something, is there a trigger here, or is this for every application?
As currently drafted, this is a trigger only when there are RBUs within 2,000 feet of the location.
Okay, so if that was the trigger, then I think it has to be the robust, because there's a trigger there. But that's my thoughts, because if there's a trigger in the rules, then folks need to know.
What are other folks thinking? Commissioner Ackerman?
Yeah, the only thought I agree with that concept. The only thought I have is that if the trigger is that it's within 2,000 feet, is the notice then, and I'm trying not to make this too complex, but it might follow that the notice would be to the appropriate people at that point, as opposed to another broad swath of an outreach.
I mean, again, I think we've got not competing, but kind of different purposes here. So we've got a situation where there is a application that's including RBUs inside 2,000 feet. That is a trigger, but at the same time, I'm hearing one of the intents here is to have the opportunity for the operator to engage with the community to better inform public comment and to make sure that the community is more clear about the application. We tend to see more community interest in applications that include RBUs inside 2,000 feet than outside 2,000 feet, although that certainly is not always the case. And so I do think that it may be most appropriate to capture both of those pieces, to have the trigger be the 2,000 feet, but then to have that robust notice requirement associated with that, because that trigger has been met and that we're hitting that half mile and 4,000 feet at that point.
Yeah, I appreciate that discussion. Thank you. That's why I raised the issue. I'm largely leaning towards, if we're talking about community meeting type situations, I do lean towards broader notice.
Others with thoughts? Leave it as is. Not seeing anybody. I think we're getting tired.
So then what I'm seeing is consensus around combining into one community meeting. The trigger remains, there's an RBU within 2,000 feet. But notice, as Ms. Trask has written, goes out broader than the RBUs within 2,000 feet. The notice goes out to a half mile outside of DIC and 4,000 feet inside DIC. That's where we're headed. Okay.
Sounds good.
I note that there is also a comment that we need language on how this invitation is to be sent. If we're consistent with other robust notice requirements, it would be mailing, but there are other options.
Commissioner Ackerman?
Thanks. And just to clarify, when we're talking about the robust, it would include mailings, but also would include reaching back out to everyone who's expressed interest through the electronic processes to this point as well, from my perspective.
I would agree with that. So as with the other community meeting, it would be a mailing, it would be emailing those who have expressed interest, social media post, and posting on the website.
Okay, moving on then, unless someone stops me. Okay, the last section is information requirements for OGDPs, so obviously not notice that is going out really. First one, and I think the question that I have is, we've got currently a mile. Would this then also be 2,000 feet? Or sorry, 4,000 feet.
Well, that's current. That's current.
Right, I misspoke. I meant the commission, the majority of the commission has coalesced around 4,000 feet. In other instances where there was a discussion about a mile, is this also a 4,000 foot situation as opposed to a mile?
think so.
Yeah, I think so.
So just to throw one thing in there, some of these do. I mean, it could be argued that some of the neighborhood stuff or the notice stuff isn't associated with an impact area, but some of these things like a DIC map and such, those are a little more closely related to impact areas. So I'll reiterate that a mile may be more appropriate in these particular situations, but these are submittal requirements versus notice requirements.
And I'm sorry, so the sort of posture of this is if the location is within X distance, then a map of where the disproportionately impacted communities are is required. But the map itself would go out how far? The scope of the impact area?
That isn't determined in rules yet. That I'm aware of or that I recall, but you're correct. If the way it's currently set up is if the proposed location is within 2,000 feet of RBUs in a DIC, then the disproportionately impacted community map is required as an attachment on the Form 2A. This is not a notice that goes out to anyone.
Okay. I mean, I think given that, I would lean towards a mile on this one as well. I think that could make some sense.
Yeah, I actually would agree on that, given that it's not a notice. So I think you got consensus on a mile.
Okay, next one. But this is, I think, fair to call these triggers, given our previous discussion. So we've got a mile trigger for a DIC map required. I think also a trigger, unless Ms. Trask corrects me, but two different triggers for a community outreach plan. There's a half a mile trigger, as is currently written in this document. Which the trigger requires a community outreach plan, half mile and a mile, depending on DIC or not.
I would keep it as is, half mile and a mile. Again, it's that outreach and engagement that ends up being really important and ultimately helps the application and gets it through the process more efficiently.
I agree with that.
Consensus on that? Commissioner Cross?
I'm curious how the outreach plan itself would be different than the notice provided pre-app and post completeness.
Commissioner, if I may, the community outreach plan is a plan that is already required in our current rules.
Yeah.
It's an attachment on the Form 2A. It's not a notice. So it describes, the plan describes to the commission how the operator intends to engage in initial and ongoing and long-term relationship and communication with the people within a certain proximity.
And so currently with that, the trigger that would require a community outreach plan is 2,000 feet. And so
Yes.
this would say, hey, if it's within 2,640 feet outside of a DIC, then we're going to ask you to do a community engagement plan to better line out how to have good relationships with the neighbors in this application. And then if it's within a DIC, it would be a mile. That would be the trigger for doing the community outreach plan. Now, the community outreach plan may be much broader than a mile because it's how an operator is showing how they're engaging with the community. I think it's up to the operator to make a determination of how they're engaging with the community. But this would just be the trigger of whether or not they need to do the community outreach plan as part of their application.
That is correct. And if I may, the trigger as in our current rules is that if there is a residential building unit that is also in a disproportionately impacted community, that is also within 2,000 feet of the proposed pad, then this plan is required. And so I think that the question about a half mile and 1 mile is, does the radius expand from 2,000 feet outward to some point to include if there are residential building units within a greater radius? Then what is that radius? So for example, there could be a location that has 3 RBUs within 2,000 feet, and none of those RBUs are in a disproportionately impacted community. The plan is not required. If there's a location with 3 RBUs within 2,000 feet, and one of those RBUs is in a disproportionately impacted community, then the plan is required.
So I will note that I'm taking this concept of at least the half mile piece from, and I might be wrong here, but I'm pretty sure because I've looked at a lot of comments, but I'm taking this from Oxy's comments indicating that that's current practice anyway. It's a good idea to have a community outreach plan and to implement that community outreach plan in a situation where you're in proximity to residents and they suggested a half. And so that's why the half mile's there. Now you can have a debate whether that 4,000 feet or a mile should be the trigger for a community outreach plan and a DIC. But I do think that it is important to acknowledge that there should be community outreach when there's some proximity to residents.
And I'm 100% in agreement on it being important to have the outreach. I'm just not, I guess I just don't understand why the trigger, if it's everything else is 4,000 feet for the trigger and DIC, why it'd be the bigger trigger for the post information.
I think I'm in agreement on that. Others with ideas? Commissioner Ackerman?
Yeah, thank you. I mean, it is difficult philosophically to go back and forth between 4,000 feet and a mile here. And so I certainly can see why Commissioner Messner tried to line those up and appreciate his efforts to do so. I think the trigger on this one is relatively narrow right now. I think that it's a doubling of that trigger corresponding to our mandate to protect DICs. If we go to 4,000 feet specifically to trigger that, I'm comfortable with that. And I'm relatively agnostic. I agree with what Commissioner Messner said outside of DICs. I'm relatively agnostic as to whether to require one here. I think it's a good practice, as Oxy stated, but on the non-DIC RBU, I could go either way.
I think it's good practice as well for non-DIC.
So
Well,
let's just do the 4,000 feet and move on then. So it's a half mile and it's 4,000 feet. We'll move on.
Thank you, Commissioner Messner. Last one, similar concept. What's the trigger? Except for this is for director consultation with CDPHE.
If I may, currently
Go ahead.
there is no rule in there's no current rule that requires this specifically in relation to disproportionately impacted communities. The August draft proposes that the director will consult with CDPHE when there are RBUs within 2,000 feet. This is something that has been done in practice. with Ms. Sorensen at CDPHE for quite a while now. And so it was staff's intent just to sort of memorialize the practice that is already occurring, where we have that consultation with Ms. Sorensen when there's a location within 2,000 feet of an RBU.
And Ms.
Commissioner,
Kelsey, is it an expansion then for inside the DICs to the half mile, or is that also current practice?
Current practice is just 2,000 feet regardless of
Anywhere.
DI status, yeah.
Okay.
And so this is
And-
just a question about expanding, if the commissioners want to expand to a half mile or some other distance in this rulemaking, in DICs.
Thank you. And then to your note here about being sensitive about the only really the inability to direct that, CDPHE consultation, but really it's a request. Is it drafted in this section? I'm sorry, I should probably pull it up. Let me just say, my thought would be, let's make sure it's drafted to say that we will request consultation regardless of where we end up with the numbers here.
I don't have that in front of me at this moment. I think it is that the director will seek or will request consultation with CDPHE. I'll have to check
Right.
on the exact language on that.
Okay, great, thank you.
I think especially if it's a request, I think we can expand it as we have with the others. And then obviously leave it up to the liaison if they think it's appropriate at that time.
Yeah, I think it's request a consultation and then CDPHE can respond or not. I think we've been consistent on that. Commissioner Ackerman?
Yeah, thank you. And I appreciate Commissioner Oath addressing that as well. This is certainly a request, and CDPHE can decline to consult at any point should they choose to do so. I was just going to make the point that Commissioner Messner made early, that this might be a good one to kind of consider in conjunction with the area of impact and line up with that in our consultative process. So I think I'd be in favor of a mile on this one in DICs.
Others with thoughts?
I'm supportive of that.
Chair,
All
if
right.
I
Go
just,
ahead.
I just can confirm that the language in the August draft says that the director will consult. And so if that should be changed to the director will request a consultation, just maybe some confirmation from you that that's the direction for us.
I think that's the direction. You're getting nodding of heads up and down.
Okay, thank you.
All right, AG Davenport.
Just one final request for confirmation. That means the trigger is 1 mile in a DIC. Is it then a half mile or 2,000 feet outside of a DIC? A half mile, I think, would be consistent with other notifications.
That would be consistent.
triggers.
That makes sense to me.
Everybody good with that? Okay.
All right, I think that wraps up consensus on this question.
I apologize. I missed my screen crashed during the 306C. Could I get a recap of that consensus so I can note it here in this document?
That was an opt-in, I believe, so there was no there were no applicable radii.
Okay,
Okay.
thank you.
Well done. That was a lift. What are folks thinking?
Mr. Chair, may I?
Yeah, go ahead.
So there are, in my view, two other things left to do. One is I believe there are a few areas that this commission has already discussed, but I haven't gotten to a point where I'm comfortable saying that there's a consensus, so I'd like to revisit those. Then I have my document showing where I think the commission has gotten consensus. I am happy to send these are the areas where I think the commission has gotten consensus out to you all to let you review it over the evening privately, and then coming back in the morning to let me know in open hearing if I've gotten anything wrong on that document.
I think that's a good plan. I also think breaking now would give commissioners time to look at the documents that I shared today during the working hours and not after hours. So I would be in favor of that being the plan, and tomorrow morning going over your two things and then having time for additional questions. And then I think we still need to walk through the draft from the beginning to the end and try to provide direction.
Sounds good. I'll get that out immediately. Chair, may I preview what I think those two areas are where I'm not sure about if there's consensus or not? May I do
Sure.
that? Okay. So I think the first one is Commissioner Messner had very thoughtful, detailed comments on modifications, or I think a different view of pre-app consultations, not making determinations at that point, how that process would work. In my view, I'm not sure the commission ever reached a consensus on that. So that's one area. The other area there was significant discussion about how ALAs and CIAs play into caps and no GDPs. I know that Commissioner Cross provided significant comment on that. And I didn't see that we got to a consensus on that either. So those are my two big areas of, I would like to know if I'm trying to determine if there's consensus on those topics. And at this point, I'm just giving you a heads up that that's what I've got rather than a request to talk about it right now.
Yeah, no, I appreciate that. Any commentary on those 2 points from AAG Davenport? Commissioner Oath?
Just on the first one, I thought there was consensus, but for what it's worth, I will say I was in agreement with those parts of Commissioner Messner's comments.
I'm happy to
Commissioner
share the
Cross?
screen to show what I've got as the points that Commissioner Messner raised, if there's bandwidth to have this conversation now.
Commissioner Ackerman?
Yeah, I wonder if I might, Mr. Chair, and maybe I'm getting ahead of us here, but I know you're going to send us out the document that you think there's consensus on, Counselor. I don't know if it would be possible for you to include that as a separate section for our review.
Yeah, I'm happy to do that.
I'm in support of the pre-application thing in case anyone wanted to know.
And if
All right.
I might, Chair, to avoid hopefully maybe some questions the hearing officer you might get in the evening, my intent is I will send you this document tonight and it will be made public tomorrow when the commission discusses it, so that it will be made public.
Yeah, I think that's fine.
Okay.
All right. I think that's a plan. Good work. We will return at 9 a.m. on September 26th for the last day of this week's Cumulative Impact and Enhanced Systems and Practices Rulemaking. Everybody have a good night. Enjoy doing your work, and we'll see you in the morning.